he did make that payment.
He did. Okay.
And I paid his restitution.
Great. All right, so let's just go on the record in that matter. So that the first matter this morning is People versus Vincent Ryan, file number 244964. That case was set today for a review hearing to monitor payment of restitution. And it does appear that Mr. What does it say?
Right.
1,000. Okay. So it does show that he made those payments. So Mr. Ziegler, Mr. Seeger, any record that either of you wanted to make on that?
There you go.
You're right, and just for the record, because it does note on the back that he was to appear in person, but I seem to remember you saying, albeit I don't have the benefit of the record, that he was not required to appear to the extent that he had made the payment.
Right. Okay. Thank you. All right. So the next matter, People versus Geraldine Frymark, file number 244989. And ma'am, if you can just come up to the podium there, please. Record should reflect Ms. Frymark's present here in the courtroom today. If I could have counsel put your appearances on in this case.
Ryan Ziegler on behalf of People, Your Honor.
Thomas Seeger appearing with an update from Ms. Frymark.
Okay. This case is set for trial to begin on June 18th. Mr. Seeger, this would be the plea cutoff. Have you had a chance to talk to Ms. Frymark about any potential plea agreements?
I have, Your Honor, and at this time, she's not inclined to accept any, so we wish to proceed to trial.
Okay. Mr. Ziegler, are the people ready to proceed on June 18th?
We will be, Your Honor.
Okay. So we'll proceed with trial as scheduled. Ms. Frymark, I just want to make sure you've had an adequate opportunity to speak with your attorney about how you wanted to proceed.
Yes.
Okay. All right. So, Mr. Ziegler, to the extent that you have not submitted jury instructions yet, I'll just ask that you submit those electronically to the court. Mr. Seeger, you don't need to submit a full set of instructions, but just any additional ones or objections that you have to any of the prosecutors. I know we've already had some motion practice in this case. Mr. Ziegler, are you anticipating any other issues that will need to be resolved before trial?
Your Honor, the only issue may be some discussion about what the appropriate instruction is regarding R&L. But I'm sure once we submit our instructions, if Mr. Seeger disagrees with mine, he'll submit his own. We can hash that out. I don't anticipate any motions.
Okay, Mr. Seeger.
Agree, Your Honor. There are no further motions. It's just a question of whether or not we're able to agree on what the jury instruction should read, and I guess the court can make that decision as we get trial in advance.
Okay. All right. So, Ms. Frymark, just make sure that you stay in touch with Mr. Seeger so that you're prepared. And I ask counsel and yourself to just be ready to go by 8:30 that morning, be here and be present. We'll proceed with jury selection and then go right into the case. Do you have any questions at all, Ms. Frymark? Okay. Thank you. That's all for today, and we'll see you on morning. And we have Mr. Lancer connected by video. Where's that? All right, Mr. Lancer, I just need you to unmute, please.
There you go, Your Honor.
All right, we're on the record in People versus Eric Lancer. This is file number 244996. Mr. Lancer is appearing by Zoom for this hearing by prior approval of the court. If I could have counsel put your appearances on, please.
Ryan Ziegler on behalf of People, Your Honor.
Thomas Seeger appearing with an behalf of Mr. Lancer.
We're set for a status conference in this case, as well as defendant's motion to dismiss. I did have an opportunity to review the motion and brief, as well as Mr. Ziegler, your response and the case law, as well as the statute governing the charge in this case. Mr. Seeger, was there anything that you wanted to present by way of oral argument?
No, Your Honor, I would just rely on my motion.
Mr. Ziegler.
Likewise, Your Honor, I would rely on my written briefing.
Okay. So again, the motion to dismiss is based on a couple of different bases. Number one, that the defendant was not, I think primarily, the thrust of the motion is that the defendant did not knowingly harbor a felon in this case because he was never advised by the police of what the warrant covered. And so therefore, he couldn't have knowingly harbored a felon if he didn't know that the warrant wanted for the individual in question was a felony warrant. Actually had no information at all as to what the warrant contained. There was some questions raised regarding the jurisdiction of the police officers, particularly the Antrim County officer, and the fact that the Antrim County officer was in plain clothes. I think those are less crucial. I think Mr. Ziegler supported adequate law to support a finding that the Antrim County deputy, along with the Kalkaska County deputy, had jurisdiction to be there, to be doing what they were doing, and to take the actions that they took. Was within the jurisdiction of Kalkaska County. The Antrim officer was acting pursuant to a warrant. He was accompanied by the Kalkaska County officer. The Kalkaska County officer was in uniform. Again, just looking at it from a standpoint of reasonableness, I don't think there's any question that a reasonable jury could conclude that those officers were acting within their authority and that Mr. Lancer was on notice that they were law enforcement officers there performing their duties. So from both a legal and a factual standpoint, I don't think those arguments support dismissal in this case. So the next question is whether or not, looking at the language of the statute and the evidence here, number one, whether there's a legal basis which the court reviews under a de novo standard, the bind over decision, and whether there was probable cause as a factual matter to bind over, which the court reviews for abuse of discretion. The charge here is, and it reads as follows: under the statute, a person who knowingly or willfully conceals or harbors for the purpose of concealment from a peace officer, a person who is the subject of a arrest warrant for a felony, and that's pursuant to sub 3 of the statute in this case. And the question is, what does that mean? Knowingly or willfully conceals or harbors a person who is subject to an arrest warrant for a felony. And looking at the language, and I understand both sides of the argument here. I think Mr. Ziegler's argument is more convincing to the extent that the knowingly or willfully applies to the conceals or harbors, not necessarily to the knowledge that there's an arrest warrant or that it's for a felony. I think the key mens rea here is that the person is concealing or harboring for the purpose of concealment from the police, a person who has an arrest warrant for a felony. And so I think the real question here is, did Mr. Lancer, or is there probable cause to find that Mr. Lancer was concealing or harboring a person for the purpose of concealing? And I think the evidence through the testimony in this case clearly supports that. Mr. Lancer was advised a number of times by law enforcement that they were looking for this individual. They asked him if that individual was there. Mr. Lancer was clearly untruthful with the police about that. I think from a probable cause standpoint, which is a very low standard, I think it's a reasonable jury certainly could conclude that Mr. Lancer was lying to the police because he knew that individual was being sought by the police, and he wanted to help that person, wanted to harbor that person, wanted to conceal that person from the police. I don't think from a factual standpoint that's a huge leap. And so interpreting the statute the way that I have, again, from a legal standpoint, I find that the knowingly or willfully applies to the concealing and harboring aspect. And from a factual standpoint, I think there's clearly a sufficient factual basis for the question to go to a jury, and those are good arguments for a jury. Those are all questions that I think a jury ultimately needs to decide. But again, from the standpoint of probable cause, there's clearly enough evidence reviewing it under an abuse of discretion standard to find that there is probable cause for that to go to the jury. So the court will dismiss will deny the motion to dismiss. And Mr. Ziegler, I'll just ask you to prepare an order reflecting that ruling by the court.
Yes, Your Honor.
In terms of going forward with the case, Mr. Seeger, I'm not sure where you're at with your client. I mean, I'm sure you wanted to find out what
Yes,
the
Your
ruling
Honor.
would be. but-
Your Honor, if you would give us an additional 30 days, either we will come back and we will accept a plea, or in the alternative, we will just ask the court to trial or docket it for trial.
Mr. Ziegler, any objection to that?
No, Your Honor.
Okay, so we'll set this for a plea cutoff in about 30 days. So Mr. Lancer, what that means is between now and then, you need to discuss any plea offers with Mr. Seeger. At our next hearing, we'll need you to have made a decision as to whether you want to accept a plea offer in this case or proceed to trial, okay?
Yes, Your Honor.
Are you at a treatment facility right now?
Yeah, I'm at TriCap in Saginaw, Michigan.
Are
Correctional
you still going?
facility. Sorry.
Sure. Will you still be there at the beginning of July?
Yeah, my expected release date was actually July 31st.
Okay. So, Mr. Ziegler, any objection to Mr. Lancer appearing by Zoom for that next hearing?
No.
Okay. So, Mr. Lancer, the court will approve your appearance at that next hearing in July by Zoom, as we're doing today. So you'll need to sign in for that, just like you did today. Okay.
Yes, Your Honor.
Mr. Seeger, anything further on this file?
No, Your Honor.
Mr. Ziegler.
No, Your Honor.
Mr. Lancer, did you have any questions about how we're going to proceed with your case?
No, I'll just contact Mr. Seeger. Thank you.
Okay, thank you. You're free to disconnect at this time.
Okay, thanks again, Your Honor.
We have Mr. Hauser connecting from Ionia County. I believe that's Mr. Hauser.
Yes, Your Honor, because he's been in Ionia County, it's been a little bit difficult to speak with him. I did speak to him prior to him going to Ionia County, and well, we had discussed quite a few things, but in any event, Your Honor, I was hopeful that I might be able to talk to him briefly by Zoom, breakout room, just to determine what he wishes to do.
Yes, for sure. If you want to sign in, then. Mr. Hauser, are you able to hear me?
Yes, I can hear you.
Okay, so Mr. Seeger, your attorney is going to connect in here. I'm going to put you and him into a breakout room so that you can have a private conversation, okay?
Okay, thank you. How you doing, Tom?
Hey, good, Mr. Hauser. So, Mr. Hauser, I canceled your
Hold on
bond.
Mr. Seeger, hold on one second. You're not quite in that breakout room yet. Mr. Hauser, you may need to click something on your end to go into that breakout room.
Yeah, they're doing it right now.
Okay. Okay, we'll just take a short recess until All right, Mr. Hauser, are you able to hear me?
Yes, I can.
All right, so we're back on the record in People versus Hauser. Again, the record should reflect Mr. Hauser's present today by video from Ionia County Jail. If I could have counsel put your appearances on this.
Brian, should we have to-
Thomas Seeger appearing with on behalf of Mr. Hauser.
Okay, Mr. Seeger, did you have a chance to talk to Mr. Hauser this morning here in the breakout room?
I did, Your Honor. Your Honor, it's my understanding Mr. Hauser is going to tender a plea as to each file. And the plea offer is that he may plead to count one in exchange the habitual offender notice and the other charge of reckless driving would be dismissed.
Okay, so he's gonna plead to count 1 in 5032.
Need to count one in each file, Your Honor.
Oh, in each file. Okay, gotcha. Okay, so 1 count of uttering and publishing and 1 count of fleeing or looting 3rd degree.
That's correct.
Yes, Your Honor.
Mr. Hauser, is that the plea agreement that you've discussed with your attorney?
Yes, Your Honor.
And is that how you wanted to proceed today?
Yes,
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, I do.
Thank you. You can lower your hand. Mr. Hauser, are you currently on any kind of probation or parole?
No, I'm not.
All right. And Mr. Ziegler and Mr. Seeger, did one of these offenses occur while he was on bond for the other ones or the other offense?
No, Your Honor, they occurred on the same date.
Okay. All right. And Mr. Hauser, you understand that you're going to plead guilty to 1 count of uttering or publishing. That's a felony that carries with it a maximum possible penalty of up to 5 years and or a $2,500 fine. You understand that?
Yes, I do.
And you're also going to plead guilty to 1 count of fleeing or looting in the 3rd degree. That is also a felony that carries with it a maximum penalty of up to 5 years and or a $5,000 fine. Do you understand that?
Yes, I do.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes,
Also, you don't have an automatic right to appeal the plea that you're making here today. Your only appeal of this plea would be by leave, which means you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty to each of these charges because you are actually guilty?
Yes, sir.
All right, these incidents happened on January 16th of 2025, is that correct?
Yes,
All right, and on that date, were you present here in Kalkaska County?
yes, I was.
All right, and while you were here in Kalkaska County, did you attempt to use some counterfeit money to pay for some goods or services?
Yes, I did.
Did you know that the money that you were trying to use was fake or counterfeit?
Yes, Your Honor.
Okay. And during the course of that, did you come into contact with a law enforcement officer from Kalkaska County?
Yes, I did.
And was that officer attempting to get you to stop your vehicle or pull your vehicle over?
Yes, he was.
Did the officer use lights or sirens or something else to indicate to you that that's what they wanted you to do?
Yes.
And did you fail to do that?
Yes, Your Honor, I did.
And did you in fact drive your car in a way as to try and get away from that officer?
Yes, I did.
All right, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Likewise, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute, court rule, in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Hauser, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. The court will set this for a sentencing hearing. Do you know how long Mr. Hauser is going to be there in Ionia, Mr. Seeger?
Yeah, Your Honor, it sounded like when I was speaking to him that he has another pending matter there. His attorney is working on whether or not the matter is going to proceed to trial, or there may be some dispositive motions. He's not able to make his bond either way, Your Honor, so I assume he's going to be there for a period of time.
Has his bond in this case ever been posted?
It was, Your Honor, there should be an order in the file, and I think it was in around May 5th or so that the court had canceled his bond.
Okay, so he would be brought here even if he was released in Ionia.
That would be my presumption, Your Honor.
Okay, so Mr. Hauser, we'll have a writ prepared for you to be transferred here for the purposes of sentencing to Kalkaska County. And you'll have an opportunity to speak with Mr. Seeger about a pre-sentence report that will also be prepared, okay?
All right.
Mr. Seeger, anything further on this file today?
No, Your Honor.
Mr. Ziegler.
No, Your Honor.
All right, thank you. That's all for today. Mr. Hauser, the court's going to disconnect at this time.
Do we know when we'll be back in court for sentencing?
It'll be in about a month, right at the
Okay.
beginning of July.
Okay, thank you.
Yep, okay. People versus Kylie Wheeler.
Your Honor, Thomas Seeger appearing as the arraignment.
Goodrich present?
Yes.
Okay, the court will call People versus Jeffrey Goodrich. File number 255023. The record should reflect Mr. Goodrich present here in the courtroom today. Also, put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with on behalf of Mr. Goodrich.
All right, this is set as a plea cutoff today. Mr. Seeger, have you you had a chance to talk to Mr. Goodrich?
I have, Your Honor. Your Honor, at this time, we've not come to a resolution. Mr. Goodrich is still trying to work out a potential resolution in Antrim County, which is somewhat attached to the tenant file here. And so in as much as I understand that this is a final settlement conference, Your Honor, I would ask the court to give us one final settlement conference. I have no objection to setting it for trial, as it may likely go that way, but he's still trying to resolve his Antrim file. If his Antrim file is resolved, it's likely that this one will likewise resolve itself.
Okay. So I do want to go ahead and get this set for trial, and then we'll set it for a final status conference. Mr. Ziegler, how much time do people need to be ready for a trial in this case?
Your Honor, we could be ready at any time.
And how many days of trial do you think we would need?
So 1 day trial, Your Honor.
Mr. Seeger,
Your Honor, just a reasonable period of time, whatever that means to the court, and I would likewise agree that it would be a 1 day trial.
okay, so the court will just conduct its usual scheduling, 1 day jury trial at the next available date, which is likely to be, at least 60 to 90 days out. The court will set it for a final status conference on the motion day prior to that date of the trial. The court will send out notices for both the date and times of both of those, the trial and the final status conference. So Mr. Goodrich, you have one more appearance before the court prior to your trial in this case. That will be the final day to enter into any pleas, okay? And you can expect that, like I said, within the next 60 to 90 days.
All right.
In the meantime, just make sure that you stay in touch with Mr. Seeger so that you're prepared to go forward. Mr. Seeger, anything else that you can address for your side on this case?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Okay. If you have any questions, Mr. Goodrich?
On that.
Okay, thank you. That's all for you. Okay, there at Wexford County, I just need you to unmute.
This is Mr. Goodman, Your Honor.
Okay.
Now, you hear me?
I can, yes. Can you just tell me your name, please?
Byron Goodman.
Okay. Have you been appointed to this case, Mr. Seeger?
Your Honor, it wasn't entirely clear to me, but I can handle it because Mr. Goodman is previously my client, or not, well, previously he's been my client, but also currently he is my client.
Okay. All right, so we'll go on the record. This is file number 2514722. This is Terry Harper versus Byron Goodman. The record should reflect Mr. Goodman's appearing today by video from Wexford County Jail. Last week, on May 27th, the court entered an order revoking Mr. Goodman's bond. It's my understanding that this is a PPO matter, that Mr. Goodman was arrested for allegedly violating the PPO. He was arraigned on that, was given a bond, was released, and then allegedly violated the PPO again. Or violated his bond, I'm sorry, at least for being arrested for operating while intoxicated, with the protected individual, the petitioner, in the vehicle with him at the time. So I guess what would be a basis for 2 violations of bond. The court issued an order revoking that bond and ordering that he be remanded to jail. And again, that occurred last week on May 27th. The court then set this for a hearing today to determine a new bond for Mr. Goodman. Mr. Ziegler, are the people involved? The people are involved in this based on the arrest, I would guess.
Based on the alleged OWI and the other attendant charges, yes, Your Honor, but we don't appear on the PPO matter unless the court directs.
Okay. Mr. Goodman, did you want to have a chance? We have Mr. Seeger here to assist you as a court-appointed attorney. Did you want to have a chance to speak with him before we go forward?
No, I just want to ask you a question. Can I ask you a question?
Okay. Yes.
Ms. Harper put in for a PPO termination, and I'm wondering why they ain't terminated yet. I got a PR bond. Yes, I messed up and violated the bond, which I understand is wrong. But she shows no fear of me because she keeps calling me and talking to me. I talk to her. We hang out together. That's why we both got arrested on the 27th or 25th for hanging out.
So-
Yeah. Mr. Goodman, I don't want you to talk about anything that you say here during this hearing could be used against you. So I don't want you to make any statements that could incriminate you.
That's
I think
fine.
I can answer your question, though. I think, first of all, Ms. Harper has to file a motion to have the PPO terminated. The court has to have a hearing and then issue an order before it's terminated, and that takes some time. It just doesn't happen automatically when she decides she doesn't want it anymore. That's not how it works. So
Right,
let
Your
me
Honor,
just
but
explain to
you
you.
know,
Let me, Mr. Goodman, let me finish explaining to you, and then we'll see if you still have questions, okay?
Yes, sir.
So the PPO is still in place, and it will be until that motion's filed and the court can hear it and sign an order to terminate it.
Yes, sir.
The PPO prevents you from having contact with her. And so that means that regardless of whether she tries to contact you, you have to say, I can't talk to you, I can't be around you, stay away from me. You know, you can't have contact with her. And I understand that that's difficult when the person who asked for the PPO is trying to contact you. That doesn't make a lot of sense, and I get that. But you cannot be around her until that order is terminated, all right?
Yes, sir.
So if she tries to contact you, you've got to get away, say, no, I'm not talking to you, I'm not going to be around you, and you need to remove yourself from that situation because you're the one who's going to get in trouble as you're finding out.
Yes, sir. Yes, sir.
In terms of a new bond here, Mr. Ziegler, are you aware of what the bond is on the OWI case?
I don't recall off the top of my head, Your Honor. I want to say it was in the area of 20,000, 10%.
Okay.
What?
So Mr. Goodman, I'm going to reinstate your PR bond on this PPO case. I think you spent a few days in jail now on this. I've had a chance to explain it to you. I think chances are that you've learned your lesson here and you understand that you can't have contact with Ms. Harper. So I'm not going to impose an additional money bond over what you're already going to be required to post in that separate case. So the court is going to reinstate your bond on the PPO, and I'll issue an order today to that effect. So to the extent you're being held in jail, it won't be on this PPO matter, okay?
Yes, sir. I got one question though. Could you
Sure.
change my address, take her address of mine and put it towards Mansalona, because she's not on my address no more. I get in trouble for that too, but Ziegler knows that Mr. Officer Creighton contacted him saying that on the sex registry, she was homeless and then she went from homeless to her new address. She no longer lives at my address. So can you clear that up too today? Saying, you know, take her name off my address so I can go back to my house without having to worry about cops showing up at my door.
I have no idea. I can't change anything about her address. I can only change your address if you have a different one.
I live at my house. They said I could live at my house. Even Ziegler did because Officer Creighton called him because Terry's in the sex registry. He left my house. He ain't been there for over a month or a month and a half. You know what I mean? Since he did this bill. She lives in Mansalona now. So
Mr. Seeger, do you know if Mr. Goodman's been appointed an attorney in that other case, the OWI case?
Yes, Your Honor. Currently I am his attorney.
You are, okay. Can you advise him on that home issue?
Relative to what, Your Honor?
I can't give him advice about whether he should go back to the house or not.
well, I can go back
So-
to the house. Ziegler says I could. And Officer Creighton did.
All right, so Mr. Goodman, I don't know if I'm prepared to discuss that with you. Let me try and set up a Zoom meeting with you or come to the jail manually so that we can discuss.
Ain't no big deal. I've been going to the house, so I'm just wanting you to take it off the address while we're in court, but if we can't do it, I'm all right, because I've been going to the house there. No, I ain't no problem. I'm just saying that's to make, switch the address.
Oh, okay, so let's just talk about it later, Mr.
Thank
Goodman.
you. All right, thank you.
Okay,
Okay. All right, thank you. That's all for today, Mr. Goodman.
All right, thanks, sir.
Do we have Mr. Barkovich? Yes, sir. Mr. Barkovich, if you can go to the podium there, please. We'll go on the record and People versus Terry Jordan Barkovich. We've got a number of files for hearing today, 25-5009, 5010, 5011, 5012, 5015. This is the date and time set for sentencing in this matter. The record should reflect that Mr. Barkovich is present here in the courtroom. And if I could have counsel put your appearances on.
Brian Ziegler, on behalf of the people, Your Honor.
Thomas Seeger agreeing with an behalf of Mr. Markovich.
Thank you. This is the date and time set for sentencing in this matter. Mr. Barkovich, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes, sir.
Oh. Mr. Seeger, just so that you're aware, I did receive a letter from Mr. Barkovich that I had a chance to review prior to the hearing today. Are there any additions, deletions, or corrections?
They're not here.
Are there any challenges to the scoring?
They're not here.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
There you
Do the people have any challenges to the scoring?
go. No, Your
Are there any victims that wish to address the court today?
I don't believe so, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, there's obviously a lot to say about the defendant and his string of offenses in this case. Fortunately, the PSI does a very good job of laying out each one of these cases individually and what happened. And the court has had the benefit of reviewing the reports for the no contest plea. As such, I'm just going to hit the highlights here. The defendant has 9 contemporaneous open files in this county. I believe that is a record, at least during my tenure. He's pending sentencing on 6 felonies here and 2 more in Antrim County. The defendant has a lengthy record and was on parole at the time. The crimes the defendant was accused of and pled guilty to were largely victim crimes, larcenies, and burglary type offenses. And one offense that was not along those lines was an attempted escape from the jail here in Kalkaska, which was on video. And the video shows him getting a significant portion of his body through the booking window, through the bars there, right in the booking window at the jail. And but for the corrections officer turning around and seeing him trying to get through the bars, it appears likely to me he would have succeeded, gotten into the control room of the jail, and then fled the facility. The defendant's record on parole, as indicated in the PSI, is poor. It includes multiple positive drug screens, multiple issues with absconding. His history on probation is poor, multiple failures on probation and other files. His course of conduct in this case involved a protracted manhunt and a string of larceny offenses, including 4 UDAAs and a home invasion to which he pled no contest. There is simply nothing to redeem the defendant, Your Honor. The guidelines are wholly inadequate to address his conduct. He's already 20 points over the maximum PRV score for his grid, and that's only scoring 2 subsequent convictions when he has 8 concurrent convictions across both this county and Antrim County. Even setting Antrim aside, because he will be sentenced in Antrim, the defendant has 6 concurrent felonies here in Kalkaska, 5 of which were entered as a habitual second. There's simply nothing to do with the defendant, Your Honor, other than to return him to prison for as long as possible to prevent the community from being further victimized. I would recommend simply Tanner ruling him on every single one of these files, Your Honor, giving him 60 to 90 months on everything but the escape, and then 32 to 48 on the escape. which runs mandatory consecutive. Barring that, I would ask the court to give him the top end of the guidelines on each offense. Thank you.
Thank you, Mr. Seeger.
Yeah, by way of elocution, PJ has had a troubled past and he's made a lot of mistakes and he recognizes that. And unfortunately for Mr. Barkovich, he's struggled with a drug addiction for an appreciable period of time and he has used that as a coping skill for himself as much as that has been self-destructive behavior, which he recognized. Prior to being released from prison, he had been dealing with the passing of his mother. I think that he was struggling with that significantly. And then when he was released, he didn't have the coping mechanisms to deal with that. Wasn't able to go to a funeral. He wasn't able to, say his goodbyes. There were a lot of things that happened. Be that as it may, Your Honor, Mr. Barkovich is remorseful for his actions. He recognizes what he did was wrongful. He accepts responsibility for it. But to his credit, in as much as I don't disagree that there's quite a few different charges, he's not a violent person per se. So he's not out, hurting people in the same way that it's somewhat characterized as being. I agree you shouldn't take other people's property because clearly that's illegal, clearly that's wrongful, clearly that's hurtful to someone else. But he's not an assaultive type person. Moreover, Your Honor, in as much as he was on parole, which is a detriment to him, those sentences run consecutive. So he lost a bunch of time for which, when he was unable to resolve his files, all that is dead time. He doesn't get any credit for it. Fair enough. He probably shouldn't get credit for it, but I would just ask the court to take that into consideration. Mr. Barkovich is hopeful that, now that he's had a little bit of time to address some of the grieving process that we need to address, that hopefully he'll be able to maintain his sobriety. Hopefully when he's released from his incarceration, he'll be able to find meaningful work. He did indicate to me that at one point in time, he did have some meaningful employment lined up, and then for whatever reason, it just all fell apart. And I think with many people, what happens is one thing happens, and then another thing happens, and then at some point, you just give up hope. And I think to a larger degree, that's what happened to Mr. Barkovich. In terms of the ultimate sentence, Your Honor, I would just ask the court to fashion a sentence within the guidelines. He is understanding that he's likely to be returned to prison. The question becomes what the court does with the consecutive portion, which is the attempted escape. In my view of the video, it is clear to me that he attempted to escape from the jail cell. He was in the booking window. He stuck his head through it. He maybe got one shoulder through it, but it wasn't entirely clear to me that he could have actually gotten through the entire bars, even if he wanted to. He may have been able to partially get through there, but I don't know as if he was going to be able to actually get through the bars. Be that as it may, Your Honor, he recognizes that his conduct was wrongful. He's asking for the court to give him something at the lower end of the guidelines with the understanding that that's going to run consecutive to the other issues. Additionally, Your Honor, I'm not sure what's going to happen in Antrim County. However, I did speak with his attorney, and his attorney had indicated that he thought that there may be a meaningful sentence that's handed out there that's not necessarily for the court to consider here. But when fashioning a sentence, I'm just trying to make it proportionate to what he did, which essentially he was on a drug-induced stealing of cars and other things that he shouldn't have done, primarily because he just wasn't thinking clearly. And that leads me back to the jail escape. He was coming off a high, and so he wasn't thinking clearly then either. In any event, Your Honor, he recognizes what he did was wrongful. He recognizes that there's a consequence. He's just asking the court to give him a sentence within the guidelines. And then in terms of the consecutive portion, Your Honor, he's asking the court to consider giving him 12 months, which is still a very meaningful thing. I would note that Officer Duran was not struck in any way. It's not a situation where he was like, tussling with a guard or another person to get out of the jail. He appeared to just try in a moment of opportunity to slip his way through the bars, which he was unable to do. The whole instance lasted maybe like 3 seconds. So if it was an attempt, which clearly it was, because that's what we pled to, it was not a meaningful, long, protracted event.
All right, thank you. Mr. Barkovich, was there anything that you wanted to say to that?
First, obviously, I'd like to apologize to the people that I victimized, and I know I affected their lives in some form or fashion. Apologize to the police force and the community for wasting their time and resources on my stupid actions. I don't disagree with the prosecutor in many regards. I look at myself a lot the same way, and that's a lot of my issues is I don't necessarily love myself or care enough about myself. Things that I've been through have brought a trauma, a different way of thinking that I use drugs to cope with. Not saying that that's the perfect solution at all. I know I gotta find a way to forgive myself and find a way to love myself again. I know I need help. I want help. The person that stands here today is not the person that did these things. It's not a person who's happy with the things that were done. But unfortunately, there's another side of me that isn't a good person. And I want help. I know I need help. I don't want to continue being like this. I understand that I deserve prison time. Only thing I do try to ask is if maybe on the consecutive charge, somehow I could get like a year in a county jail where I can be afforded opportunities like teen challenge or rehabs or things that will actually help me in the long run. So I can be the person like I have good trade skills, getting jobs and employment. I went from making $50 an hour to this. Like, I can be a productive member of society if I can get rid of the other side of me and learn how to deal with my addiction. I did some outpatient things. I've never been to like a rehab or a place where I have an extensive plan put in place to help me. Like, yeah, prison's prison, like being around a bunch of negative influences, drugs, corruption, that's a hard place to change in. I'm not saying that what I did doesn't deserve that, but I also, at some point in time throughout this, would like to get the help I need. That's all.
I did read through the report. These circumstances of this kind of string of crimes that you engaged in November of last year here in Kalkaska. There's obviously a lot of information in that report about you personally, your background, history, and so forth. I take all of that into account. Like I said, I also read your statement very carefully. Take that into account along with what the attorneys have had to say. And you know, I thought your statement was interesting because when I see the charges, when we took the plea, when I read the PSI, it's like, what is this person? Is this just somebody who's just a criminal, or are they going through something that's causing this kind of behavior? You know, are they just a bad person? Or, you know, in your case, I don't think that's the case based on what I read and just based on your history. I thought your statement was pretty sincere in terms of admitting where your fault is here. And I think you're probably not a bad person deep down, but you do have issues when you're under the influence of substances, and you do a lot of bad things and you victimize other people. And the problem with that is that the people that are victimized, it doesn't matter to them what your reasons are. They see the outcome of that and they see the effect on their lives that it has. And I say that because I think, you know, there is the potential for rehabilitation if you're going to put in the work to do that. Because I don't think you're just, you know, a criminal at heart who's just going to victimize people because you have this drive to just victimize people. I think you do bad things when you're under the influence and you're not in your right mind. Again, that's not an excuse, but I think it's an explanation, and I think it goes to the potential for rehabilitation in your case. That kind of rehabilitation hasn't happened yet, and I think from the court standpoint and the community standpoint, given your record, that point is passed in terms of when the court's going to order that. That doesn't mean that you can't seek that out, like you said, once you've served your time here, seeking out resources and treatment to help yourself, because you don't want to get back on this Ferris wheel again. But at this point, that's going to be up to you to determine how you want your future to be and what actions you're going to take on your own. Because of your past history, because of the string of crimes in this case, because of the effects that it has on the victims, the court's not in a position to do that. In terms of the prosecutor's position that the court should go above the guidelines and sentence you to the actual maximum extent allowed by the law versus you through your attorney request for the court to sentence you at the lower end of the guidelines. I think the sentence in this case is going to be sufficiently punitive because of your parole status, because of the consecutive nature of the escape charge, that going above the guidelines isn't warranted, and because I do think there is some potential here eventually for you to get some help for your underlying addictions, for the underlying trauma that you're treating with those addictions, that the court should not go above the guidelines. But I also don't find, again, based on your past history, the effect on the victims here, that there's any reason to go lower than the upper end of the guidelines on all the charges. So for those reasons, the court finds the following sentence is reasonable and proportionate. As to file number 255009, unlawful driving away, the court sentences you to 36 months to 7.5 years in the Michigan Department of Corrections with credit for 0 days served, a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to file number 5010, the UDAA charge, court sentences you to 47 months to 7.5 years in the Michigan Department of Corrections, a crime victim's assessment of $130, and a state cost of $68. As to file number 5011, I'm sorry, I'm gonna discuss that one last. As to file 5012, unlawful driving away, court sentences you to 47 months to 7.5 years in the Michigan Department of Corrections with credit for 0 days served, crime victim's assessment of $130 and a $68 state cost. As to file number 5015, on the charge of UDAA, 36 months to 7.5 years in the Michigan Department of Corrections with credit for 0 days served. As to count 2, the home invasion, 36 months to 7.5 years with 0 days served credit. On that file, $130 crime victim's assessment and $136 state cost. All of those files to be served concurrent to each other, but consecutive to any penalty for parole violation. As to file number 5011, which is the escape charge, the court sentences you to 24 months to 4 years with credit for 0 days served, a crime victim's assessment of $130 and a $68 state cost. That sentence to be served consecutive to your parole violation and consecutive to the sentences in files number 5009, 5010, 5012, and 5015. You do have the ability to seek an appeal of each of these sentences. We're going to provide you with some paperwork that explains to you what your appellate rights are. Mr. Seeger.
For the record, returning a copy of his appellate rights to the court, giving him a copy of his own.
All right, thank you. Mr. Barker, if you are remanded to the custody of the state at this time. All right, sir, can you tell me your name there at Wexford County?
Derek Williams.
Travis, are you ready on this one?
We are, Your Honor.
Protocol People versus Derek Williams, file number 255043. The record should reflect that Mr. Williams is present today by video from Wexford County Jail. Recording sheet here. Okay, we're back on the record. Again, People versus Derek Williams. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Williams, Your Honor.
Thank you. Mr. Travis, can you tell me the status of this file, please?
Yes, Your Honor. We waived the preliminary exam in this matter based on an offer of a use of methamphetamine. The underlying charge is possession of methamphetamine. Mr. Williams would like to avail himself of that offer and enter a guilty plea to the misdemeanor charge of use.
And is that's a 1-year misdemeanor?
It is.
Okay. Mr. Williams, were you able to hear that?
Yes, yes, sir.
Have you had adequate opportunity to speak to your attorney about that plea agreement?
Yes, sir.
And is that how you want to proceed today?
Yes, sir.
Okay, Mr. Williams, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes,
Thank you. You can lower your hand. Mr. Williams, are you currently on any kind of probation or parole?
no, sir.
All right, and you understand that the maximum possible penalty that you could face for the charge of use of methamphetamine is up to 1 year in jail?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself if you wanted. Do you understand all those rights?
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we've said here in court today?
no.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty because you are actually guilty?
Yes, it was on me. Yes,
All right, so counsel, is this date correct? The date on the information is 2020?
It is.
Yes, Your Honor.
All right, so this occurred some time ago, Mr. Williams, back in 2020. Do you remember that incident back on September 5th of 2020?
yes. I kept calling Kalkaska, letting them know that I would be there to take care of that matter.
Okay.
Yeah,
Do you remember being You remember being here in Kalkaska back on September 5th of 2020?
Yes, I was picking up my girlfriend to bring her back to
Okay.
Oklahoma.
All right, and the time, at that time, when you were here in Kalkaska County, did you have some methamphetamine?
It was in my coat pocket. I had the glass stem in my coat pocket.
Okay,
There's a pipe, Your Honor.
all right, and did that have some methamphetamine residue on it?
Yeah, inside of it, yes, it did.
And did you have any right to have any amount of methamphetamine at that time?
No.
Okay, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, sir.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people satisfied, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Williams, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. Mr. Travis, how did you want to proceed with sentencing in this matter?
Your Honor, I've spoken with the prosecution, probation, and Mr. Williams, and we were going to ask the court to proceed directly to sentencing.
All right, Mr. Williams, do you have any objection to having the sentencing hearing right now?
Right, go ahead. No, I don't have any problem.
Okay. Mr. Ziegler, anything you wanted to say regarding sentencing in this case?
Your Honor, as the court has already noted, this is a relatively old case. I think the warrant was issued in 21, and it just, I don't believe he was in the state of Michigan, or if he was not here frequently. So it just took some time to track him down. The plea was to a use of methamphetamine. I believe Mr. Williams has remained in custody since his arraignment in March 19th. So he would have around 74 days credit already. Given that, Your Honor, and given that it's a misdemeanor, I would just ask the court to sentence Mr. Williams to time served with any fines and costs that are statutorily required.
Thank you, Mr. Travis.
Yes, Your Honor, we would similarly ask the same. I would know Mr. Williams is, his wife resided here back then. He was up to pick her up. He resides in Oklahoma, has for the majority of his life. He came and turned himself in to take care of this case. One of the things that kind of brought this to light is he was explaining to Your Honor, contacted the court, attempted to plea by mail, didn't really understand just the differences between here and Oklahoma. But it came to a head because he and his wife were planning to move to Florida, and he was talking with folks about getting a job in Florida, and this came up. And so he came back to Michigan to deal with it. So I think that shows a reasonableness we don't often see. And I would just note that it's his intention to hopefully move to Florida and get a job, but if not, he would return to Oklahoma, where he's generally resided his entire life. Thank you, Your Honor. And he also has a very, very limited criminal history, no felonies or anything of that nature.
All right, thank you. Mr. Williams, anything that you wanted to say today?
No, I just I come to take care of me and my wife's business. Like I said, I'm 60 years old. I just retired from the United States Postal Service. Also, I was hired from Homeland Security, and I'm planning on either getting back to Homeland Security when I get to Florida. And when I got stopped for this particular deal, the officer, he let me go, and I'm like, man, that's a miracle. And I'm telling my wife, see, you got to do the right thing, because her father told me to come and get her. She was with the wrong crowd, and we broke up in Oklahoma, and she came back to Michigan. I don't know Michigan, so I'm just lost here in Michigan. But I was letting my wife know that when you do the right thing, being a productive citizen of the United States or any state you're in, it pays off at the end when you just do the right thing. And so my wife, she's been clean and sober 5 years. 2020 when I got it and brought her back here and to Oklahoma. Well, I'm not in Oklahoma, but brought her back to Oklahoma. So she's 5 years, and she's doing well. Got a kind of she's got mental like bipolar or something she got. Grand Lake Wellness. We're trying to figure it out. But other than that, we're doing great. And I knew I had to come and face my past, and this is my past. And so when I leave from here, Judge, you won't see or hear from me, not on this side of the law, maybe on the right side of the law. And basically, that's all I have to say.
All right, okay, thank you. So based on what you've had to say, what the lawyers have had to say about the circumstances here, I'm satisfied that this is an isolated incident that occurred, 5 years ago. I think as has been acknowledged, I think it's admirable that you've come forward to get this taken care of in the way that you have. And so I think that warrants consideration as well. And I think that the time that you served on this charge, waiting for this to get resolved, is more than adequate to address your wrongful conduct in this case. So the court is going to sentence you to 74 days in the Kalkaska County Jail with credit for 74 days served. The court is required to impose a state cost of $50, a crime victim's assessment of $75, court costs of $325, and an attorney fee of $350. You do have the ability to seek an appeal of this sentence. If you wanted to do that, you would need to file that appeal within 21 days of today's date. If you had other questions about that, you could, Mr. Travis would be able to explain that to you. Otherwise, you should be released. I'm not sure what procedure are they following when somebody's released. Do they transport them here to Kalkaska and process them, or are they released directly from Wexford County?
Sir,
They can request to be released in Wexford, they're brought here.
Okay, so that process will start today, Mr. Williams, to get you released, okay?
okay, is it any way that they can transport me to, my wife got all our personal business, my bill folded, my lawyer he know, I was trying to get there where my bill folder and my driver's license and all my personal items is criteria is there.
So the situation is, Your Honor, his wife had a warrant out of Petoskey. So when he basically turned himself in, he gave her all his belongings, but she was then picked up on a warrant from Petoskey. So we believe actually his wife's going to be getting out today from Petoskey, but all his identification is up in Petoskey most likely. But it would be closer to be released here than Wexford if he's trying to get to Petoskey.
Yeah, so we'll have you processed here in Kalkaska, Mr. Williams, and then from there, I don't have any control over what
Okay,
happens after, okay?
okay, I'll talk to Sergeant Tiller. Tiller's good.
Yeah, okay.
Tiller.
All right, thank you. That's all for today. The court's going to disconnect at this time.
Thank you, Your Honor.
Can I get the PAT code for that?
I will get it to you.
Oh.
I got it right down.
Do you have Mr. Chapman, Mr. Travis?
Mr. Chapman is here in the courtroom, yes, Your Honor.
So we'll go on the record as People versus Wyatt Chapman, file number 244957. The record should reflect Mr. Chapman's present here in the courtroom today. If I could have counsel to put your appearances on.
Brian Ziegler on behalf of you, Your Honor.
Kyle Travis on behalf of Mr. Chapman.
This is set for a status conference. I know that a criminal responsibility report was requested. That's been received. I did have a chance to review that. I'm sure counsel has as well. So in terms of proceeding with the case, Mr. Travis, have you been able to talk to Mr. Chapman about how he wants to proceed?
Yes, Your Honor. And I've spoken with Mr. Ziegler. We did, I believe, get an offer when we waived the prelim to a joyriding or the 2-year version of unlawful use. And Mr. Chapman would like to accept that plea offer.
Okay, so the maximum penalty is 2 years?
Correct, sir.
Okay, Mr. Ziegler?
That's correct.
Mr. Chapman, have you had an opportunity to talk to Mr. Travis about this agreement?
Yes, Your Honor.
Is that how you want to proceed as well?
Yes, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Mr. Chapman, are you currently on any kind of probation or parole?
No, Your Honor.
And you understand that the maximum possible penalty for this charge of, what did you say it was? Joy?
It's called unlawful use of an automobile, Your Honor.
Okay.
Sometimes referred to as joyride.
Okay, unlawful use, that the maximum penalty for that is up to 2 years in jail or prison. Do you understand that?
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm gonna go through those with you. Did you have a question?
It just feels like I should be playing not guilty, but yeah. I guess I have to plead guilty, sorry.
Do you want a chance to talk to Mr. Travis?
Yes, please.
Okay.
Yes, I would like to plead guilty, Your Honor.
Okay, so you are pleading guilty, is that correct?
Yes.
All right. So right now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights,
Yes, I do.
and you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes,
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes,
Are you pleading guilty because you are guilty of this charge?
yes,
The information I have indicates this happened back on August 1st of 2024. Is that the correct date?
I believe it was July 31st, Your Honor.
Okay,
Maybe it was August 1st though, but I just know it was at the very end of July.
okay. And at that time you were here in Kalkaska, is that correct?
Yes,
And did you take possession of someone else's vehicle while you were here in Kalkaska?
I did.
And did you drive that vehicle?
yes,
And did you have possession, I'm sorry, permission from that individual to use or drive that vehicle?
No.
Mr. Ziegler, are the people satisfied with the factual basis?
I'm satisfied.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
And the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to check in with Agent Barrett from the probation department for a pre-sentence report. Make sure you stay in touch with your attorney, Mr. Travis, okay?
yes, sir.
All right. Thank you. That's all for today.
Thank you.
People versus Nathan Canfield. Case number 244979. Mr. Canfield present here in court today.
Your Honor, I have had no contact with Mr. Canfield.
That's another one where we're checking on restitution.
Oh, okay, I have them up on my system here, so
Well,
let me
I
check.
don't know that we need to file, but if you can look.
Yeah.
This was set for a restitution review hearing, so the court is going to check with the clerk and see where that stands.
I don't show that any payments have been made.
Is he on probation? Do you know, is he on probation, or I'm assuming the court set this for a review because he didn't get probation? It's the only way to keep track. Okay. All right, and Mr. Travis, you indicated you've not heard from Mr. Canfield.
No, Your Honor, in reviewing his file and looking at his PSI and things, he was incarcerated the whole time I represented him. And so I never had a phone number for him, and probation did, I don't think he had a phone. And I have not since had follow-up contact, and I don't have any way to get a hold of him.
Okay.
Going through I'm sure someone could get a hold of him, but I didn't have an address or a phone number to reach out to him at.
All right. So in light of Mr. Canfield's failure to appear today, along with the court record, which indicates that he has not paid any of the restitution, and considering that the purpose of this hearing was to review payments towards restitution at the time of sentencing back in January, the court will request that the people issue a bench warrant for Mr. Canfield's arrest. We'll proceed further once Mr. Canfield's brought before the court. Yeah, Mr. Hun.
He would be, I believe, on Zoom. He's incarcerated.
Not connected yet. Are you ready on Ms. Weaver's case?
Yes, sir.
Okay, so we'll go on the record in People versus Ann Weaver, file number 244983. The record should reflect that Ms. Weaver is present here in the courtroom today. If I could have counsel with your appearances.
Ryan Ziegler on behalf of people, Your Honor.
Kyle Travis on behalf of Mrs. Weaver.
Thank you. Ms. Weaver, this is the date and time set for sentencing, and you had a chance to go through the pre-sentence report and talk to Mr. Travis about that.
Yes.
Mr. Travis, are there any additions, deletions, or corrections to that?
Well, yes, one substantial update that the restitution has been paid.
Mr. Ziegler?
I can confirm that, Your Honor. We're in receipt of a check for $54,000 from Ms. Weaver to the victim. We're still working on dispersing that, but it's been paid.
Okay. Any other additions, deletions, or corrections?
Not that I'm aware of, Your Honor.
Any challenges to, I'm sorry, this is one misdemeanor, so there are no guidelines. Mr. Ziegler, any additions, deletions, or corrections?
No, Your Honor.
And do you have any victims that wish to address the court today?
So,
Anything on behalf of the people for allocution?
Your Honor, this has been somewhat of a long road. But at the start of this, the primary concern in my mind and in general in these kinds of cases is making sure the restitution gets paid. And in this case, the amount of restitution was obviously substantial. It was over $50,000. I had made this offer with every expectation that that restitution would probably never be paid, and we would end up with some different plea. I'm reasonably satisfied that the case is ending in this way, where the victim is going to be made whole. So I'm happy to resolve it with a misdemeanor in that sense. The only remaining question is what the penalties should be for the misdemeanor. I think, given that it's a 1-year misdemeanor, Your Honor, she already has credit for 131 days. The financial penalties are going to be meaningful. I'm satisfied with what has occurred in this case to this point. I certainly understand probation and parole's recommendation for a full year in jail. I'm not going to say she's not deserving of that, given her record and given what she did in this case. But from the people's perspective, Your Honor, the primary goal of bringing these cases is to make sure the victim is made whole. And that has happened in addition to some significant amount of jail and punitive fines and costs. So I'm satisfied either way, Your Honor.
All right, thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, this was a large amount of money. It was Mrs. Weaver's intention, and she pled, and she knows this is not how this should have been done. She was intending to start up a business. There's actually a tow truck that's kind of a mess relative to this case that was seized as evidence of some significant value that's in impound. Ms. Weaver's probably we don't know yet what the impound yard is going to do, but there's indications that they're going to give her a hard time about getting that truck back, even though it was placed there as evidence. So a lot of these funds were intended to help Ms. Weaver start this business, and it was her intent to basically live with her aunt and mother and take care of them and exist as this family unit. They did things clearly inappropriately. That's why we're here. But it wasn't the ultimate goal to just run away with this money and do whatever she wanted. Albeit it is quite serious, the fact that the money's paid back, the fact that the difficulties financially are not over for Mrs. Weaver. She's taken out a substantial loan to pay this back and is going to have to work to get this money back. Because of this case, wise or not, or appropriate or not, the business she was trying to develop and start was completely derailed and really had no chance to get off the ground. I don't know if that would have been successful or not, but there was kind of a whole ball of things that did not work out how Mrs. Weaver envisioned. I just note that, to Your Honor, because it wasn't as though she was just running off with a large sum of her aunt's money, albeit she knows what she was doing wasn't what she should have been doing. So we would ask the court to sentence her to time served. She's done, a true 5 months with good time, what would be 6 months, which is half of the penalty. And she still is going to have troubles from this going forward financially. So it will not be over for her, even if Your Honor does sentence her to time served. There's still going to be issues for her to deal with out of this. Thank you, Your Honor.
All right, thank you. Ms. Weaver, anything you wanted to say today?
Basically, Mr. Trevor has said it all. It wasn't intentional to embezzle money from my aunt. I really came up here with nothing, tried to start a business, and it became a whole ball of, we did not do it the proper way. I've learned a great deal lesson with this. So yes, I would obviously prefer time served at this point, because I still have to make house payments now of a bigger amount than I was making payments back to my Aunt Gert, along with my tow truck, a $17,000 truck that has been impounded by the state of Michigan. that I really can't afford to get a lawyer, pay $5,000 to fight the state of Michigan and or 258 tire, which I have been informed that they will try to take my truck and fight me for it. I can't do that and start a business and keep my payments and just do everything properly. So it's kind of stressful at that point. I don't know if you can do anything about that or if there's anything that can be done. But to have that truck released and at least taken back to their residence to where the truck was taken, and then I can have somebody pick it up to resell it to try to recoup some of this money.
All right, I reviewed the pre-sentence report. There's details about what happened in this case in there. There's also information about your past history, your background, your circumstances.
Absolutely.
And so forth. And so the court takes all of that into account when determining what is an appropriate sentence in this case, along with what you've had to say here today and what the lawyers have had to say. I do think, you know, if you were somebody who didn't have any kind of past criminal history at all, I might be willing to buy that this was a completely innocent, oh, I was just looking out for my aunt and trying to help her out. I don't believe that. I think there was a large sum of money here that you had access to. I think that was a temptation that you were unable to resist, and you thought of ways that you could spend that money to better your life. If you can make some kind of argument that that was going to collaterally benefit her too, that'd be great. But I don't think your true intention here was to help out your aunt. I think your true intention here was to help out yourself. So I don't believe that this was just a completely innocent use of the money. And so I think the fact that charges were brought is appropriate. And I also think that the jail time that you served is appropriate. I also think that, you know, to your credit, you've done a lot to try and get this paid back, and you've done that. So I think that deserves some recognition as well. In relation to your wrongful conduct. And so I think balancing those two things, I tend to agree with the prosecutor. There's been a punitive aspect to this that addresses your wrongful conduct. There's been full restitution to the victim, which is an important consideration, mitigates your wrongful conduct. And it does sound like, you know, you're still going to be cleaning up some of this mess, and you're going to suffer some additional penalties financially as a result. So because of all of that, I don't think the court needs to impose any additional jail time. The matter with the truck is not under my jurisdiction. Also, there's nothing I can do as part of your criminal case to address that. That's something that you have to seek your own remedies for. But again, I do think the resolution here is appropriate with time served. So the court is going to sentence you to the Kalkaska County Jail for 131 days. You do have credit for 131 days served. The court is not going to order restitution as part of the sentence because that's already been paid, but the court will impose the statutorily required fines and costs, which include a crime victim's assessment of $75, court costs of $325, attorney fees of $350, and a $53 state cost. You do have the ability to seek an appeal of the sentence. If you wanted to do that, you would need to file your appeal within 21 days. If you have more questions about that, Mr. Travis would be able to help you with that. Otherwise, you just need, after you're done with court today, you just need to go to the clerk's office to make arrangements for payment of those fines and costs. Mr. Stigler, anything further for the record?
No, Your Honor.
Mr. Travis.
Nothing further. Thank you.
Good luck to you going forward. Mr.
Thank you.
Thank you.
Is this Mr. Hunt?
It is, Your Honor.
Can I get by?
Mr. Hunt, are you able to hear me okay?
Yes, I can, sir.
All right, we're on the record in People versus Thomas Hun. This is file number 5255028 and 5041. The record should reflect Mr. Hun is present by video today from Wexford County Jail. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Hun, Your Honor.
Thank you. Mr. Travis, how did we want to proceed in these files today?
So, Your Honor, it's my understanding that the prosecutor would offer to resolve as a global resolution if Mr. Hun pled to one count of operating while intoxicated, third offense, and then in the second file, a count of resisting and obstructing. And it's also my understanding on the resisting and obstructing, we would be asking the court to take that as a no contest plea due to intoxication and lack of memory.
All right, so with that, because we have OWIs in both files, so are you saying dismiss one file, lead to an OWI third in one, and RNO as an added count?
That's correct, Your Honor. I'm not picky as to which OWI it is, pleading to one OWI third offense in either of the files.
Okay.
And then in file 5041, an added count of resisting and obstructing instead of the police assault on a prison employee.
Okay, so I think for court records, I think it would be cleaner to just dismiss file number 5028, have them plead to count 1 and 5041 and added count 5.
I understand that, Your Honor. The reason, well, there's two reasons. One is there may be a scoring issue with him pleading in the second file. The other one is, in just looking through, I didn't have, I couldn't find the blood result from the most recent file. And Mr. Hun had indicated that he couldn't remember that one, so that would have to be a no contest to both. And I was struggling to put together appropriate reports to hand to Your Honor to make that no contest plea to the drunk driving myself.
I do have a blood result in, I believe, both files, but at least the second file, Your Honor. So I don't know if the defendant would be able to lay a factual basis to it, but it exists.
Do you have a police report for the RNO?
I do, Your Honor.
No problem with that.
Yes, sir.
So, all right, I guess I'll leave it up to you, Mr. Travis, then as defense counsel, what file you want. What file you want, what OWI you want, Mr. Hunt, please.
So I would ask that we plead in file 5028 to the OWI third.
Okay. All right, so Mr. Hun, I know we've been going back and forth a bit here on some technical matters, but ultimately, what the plea agreement is that you're going to plead guilty to one count of operating while intoxicated as a third offense and no contest to one count of resisting or obstructing a police officer. Is that the plea agreement that you've discussed with your attorney?
Yes, it is. I'm terribly sorry. I didn't mean to bother anybody. I don't remember the whole incident at all. I don't even remember leaving my son's house.
All right, so that's fine. That's why we'll take the no contest plea on the one charge, okay?
Right.
But you want to plead no contest to the RNO or resisting and obstructing, is that correct?
That's correct.
And then plead guilty to one count of operating while intoxicated third offense, is that correct?
Yes, sir, Your Honor.
And the prosecutor would drop all the other charges. Is that your understanding? And then the prosecutor would drop all the other charges, is that your understanding?
I guess, yes.
Okay. Can you raise
I
your
don't
right hand?
recall.
All right, do you need more time to talk to your lawyer about the plea agreement?
Right.
Yes, you want more time to talk to him?
No, I don't believe so.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Mr. Hun, are you currently on any probation or parole?
No. No, I
Okay.
wasn't, no.
All
I
right,
guess I
and
was
you
on
understand that?
Probation no. I was out on bond.
Okay. You understand that the maximum possible penalty you could face for operating while intoxicated, third offense, is up to 5 years and or a $5,000 fine. Do you understand that?
Yes, sir, I do.
And with that penalty in mind, what is your plea to that charge?
No contest.
Travis, do you want to have a chance to talk to Mr. Hahn here? I think we've got some misunderstandings.
I'm sorry, maybe I missed something, Your Honor. Were we talking about the R&O charge, or were we talking about the?
No, I just told him the maximum penalty for the OWI third and asked him how he wants to plead, and he indicated no contest.
So, Mr. Hun, for the R&O, we wanted to plead no contest, correct? Because you don't remember that.
That's correct.
But for the drinking and driving that happened in December, you recall that, don't you?
Yes. Some.
Okay, so you were driving your car on December 4th, is that correct?
On December 5th? On when?
December 4th.
My truck, yes.
Okay. And the judge had asked you, how do you want to plead? He's asking about that first drinking and driving. So do you want to plead guilty to that charge?
Yes.
Okay. And you had been consuming alcohol on December 4th before driving, is that correct?
That's correct.
And you had consumed enough alcohol to be over the legal limit, is that correct?
That's correct.
And you may not remember this, but there was a blood draw with the result of a 0.179. Does that sound right?
That's
Your
right.
blood alcohol? Okay. And you were in Kalkaska County when that occurred?
That's correct.
And prior to that, you had been convicted of drinking and driving. Is that also correct?
Correct.
And one of those convictions was back in October of 2017 here in Kalkaska.
Yes.
Okay, and was another one of those convictions in March of 2020 here in Kalkaska?
Yes, correct. Yes.
Okay, and do you
That's all
recall?
I'm noting.
And you pled to those
Did I what?
drinking? Pled guilty to those drinking and drivings?
That's correct.
And you knew that you could have had a trial if you wanted to?
Do what?
You knew that you could have had a trial if you wanted to. You didn't have to plead guilty on those two
That's
previous
correct.
ones.
I could have, yes.
Okay,
Are
all right,
you-
thank you.
I suggested I have a trial.
No, it's just required that you knowingly pled. That's all. Just
I see.
that you knew your rights.
All right, Mr. Hun, I need to go through a few other things with you with regard to your rights, okay?
All right.
So you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor. I'd like to ask
Has it-
mercy of the court.
Has anybody threatened you with anything to get you to plead guilty or no contest in this case?
Nobody offered me anything.
Has anybody promised you anything other than what we've talked about here today in court?
No, sir.
Is it your own free choice to enter these pleas?
Yes, sir.
Okay. So Mr. Ziegler, in terms of the factual basis for the OWI, are you satisfied with that?
I am.
In terms of the no contest plea, I have before me a report from.
This won't happen again.
Okay, just hold on a second, all right? Mr. Hun, I gotta talk to the lawyers about something for a minute, okay?
All right. I'm done drinking.
All right, good. I'm looking at Kalkaska Sheriff's Department report from Deputy Beaver, dated March 13th, 2025. The court is going to mark that as Court Exhibit 1. Have you reviewed that report, Mr. Ziegler?
I have.
And would you agree that that would provide a factual basis to support a finding that Mr. Hunt is guilty of resisting and obstructing?
I think Mr. Travis has just provided you the first page of that report, Your Honor, but I agree that the information contained therein is sufficient.
All right. And Mr. Travis, have you also looked at that exhibit?
I have, Your Honor.
Would you agree that it would provide a factual basis for a finding of guilt as to resisting or obstructing?
I do. I picked that particular page because it was pretty concise and seemed to cover everything.
Okay, I've reviewed it here and I agree. So the court's going to admit that as Court Exhibit 1. And Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis, are you?
I am not, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest guilty plea today?
I am.
Mr. Travis?
Yes, Your Honor.
All right, Mr. Hun, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied as to both charges that there are a factual basis to support a finding that you are guilty of each. The court will accept your pleas today. We'll set these matters for sentencing. Between now and the sentencing hearing, you'll be contacted by probation department for a pre-sentence report. And then you'll be transported here to Kalkaska to have that sentencing hearing here in person. Do you have any questions?
Not at this, no.
Okay, Mr. Hun, that's all for this hearing today. We're going to disconnect at this time.
All right, thank you.
Thank you. People versus Scott Way, case number 255002.
Your Honor, can I have just a moment to talk with Mr. Way?
Yes, let's take a short recess and we'll come back on the record. All right, we're back on the record in People versus Scott Way. The record should reflect Mr. Way is present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Travis, on behalf of Mr. Way.
Thank you. This is the date and time set for sentencing in this matter. Mr. Travis, have you had a chance to go through the pre-sentence report with Mr. Way?
We have, Your Honor.
Mr. Way, did you have an adequate opportunity to go through that report and talk to Mr. Travis about that?
I did.
Mr. Travis, are there any additions, deletions, or corrections to that report?
Yes, Your Honor, I have two letters for the court. Addition, Mr. Ziegler and I have been discussing a objection or a correction or in the body of the evaluation and plan that I was intending to make, given it relates into Mr. Ziegler's objection to the scoring. We were just having some discussions, making that less clear than I initially thought, but I guess I should still make my statement. Okay. So in the fourth paragraph down, it indicates he was engaging in a long text conversation, Snapchat, and Telegram with someone he believed to be a 12-year-old female. And in the attachments to Mr. Ziegler's motion, it doesn't state an age, but then in going through the report, the gentleman from Predator Hunters states he was posing as a 12-year-old. I initially, in going through the messages, did not see anything that referenced age. There was some text that referenced normally liking girls that are 18, but it didn't have an age. Mr. Ziegler then pointed out to me, and this is the kind of the tricky part, I don't know, and I think Mr. Ziegler will more fully argue it. At the end of, at least in the police report, the text string between Mr. Way and the alleged 12-year-old, who was not, who was a 40-plus-year-old man in Texas, there is a text where it says, where they're discussing their age. I'm 25. Oh, I'm 12's LOZs. But that appears to be, and I think Mr. Ziegler will say that's not the case, the last text in that conversation string. Because then I think starting after that is a text string, which I believe is between Mr. Way and someone who's talking about other things. I think the Predator Hunter gentleman, but I'm not real sure. So what I was trying to figure out was, did any reference to age preclude any of the negative or what could be inferred to be an accosting a minor, which is what Mr. Ziegler is going to argue later, is that Mr. Way was accosting a minor. And it's gotten even more muddy as we've talked about it personally. When I came here this morning, I didn't think it was there. Mr. Ziegler pointed it out to me that it is, but now what I don't know is necessarily where in the conversation the age revelation comes, because, and I'm kind of getting ahead of myself, but this is all important to Mr. Ziegler's argument that there is another felony, there is an accosting a minor, because accosting a minor requires either that they be a minor or that the defendant believe they are a minor. It's a one or the other. They don't actually have to be a minor. So it's somewhat important to that conversation whether the age portion of the alleged minor was raised or not, because then I would argue, Mr. Ziegler, the reason it wasn't charged is because it was a critical element was arguably failing in that charge. The argument that Mr. Way was aware or of a belief that this person who wasn't a child was a child, and that's all you have to establish to make that. So we're kind of spinning around at the moment on that, but that is my general objection is I previously, in going through everything this morning, would say that's Mr. Barrett's belief that Mr. Way knew he was talking to a 12-year-old. That's my objection.
Okay. We're gonna pass this case for now. This is gonna take a bit of time to hash this out, I think, and we're behind in the docket. I've got some hearings that are waiting on video. There's some others that aren't gonna take quite as long, so I'd like to take some of these other cases. So let's pass this for the moment. Let's come back to that. So Mr. Way, if you can just be seated, we'll come back to your case. Sir, at the Wexford County Jail, can you tell me your name, please?
Eugene Hiddle.
Okay. We'll go on the record in People versus Buck Hiddle. This is file number 234859 and 255049. The record should reflect Mr. Hiddle present today by video from Wexford County Jail. And if I can have counsel put your appearances on.
Ryan Ziegler on behalf of people.
Kyle Travis on behalf of Mr. Hiddle, Your Honor.
Thank you. Mr. Travis, how did we want to proceed in these files today?
Your Honor, it's my understanding Mr. Hiddle would like to accept a plea offer. That plea offer would be pleading to a resisting and obstructing in both felony counts in front of Your Honor. Would dismiss all other counts and all other enhancements. It would also dismiss a number of misdemeanors that he's currently charged with, would preserve restitution for the 2 retail frauds, and would also dismiss a retail fraud that Mrs. Hiddle is a co-defendant on.
So 1 count in each file of resisting or obstructing, is that correct, Mr. Ziegler?
That's correct. Restitution to be preserved on any and all of the misdemeanor files that would be dismissed as part of the agreement.
Okay. Mr. Hiddle, were you able to hear all of that?
Yes, I was.
All right. And is that the agreement that you've discussed with your attorney?
Yes. Is there any way that I could have a few minutes to talk to him before I accepted it, or?
Yep. I'm going to put you on hold and then we can allow you to do that. Mr. Travis, if you want to, can you sign in? Okay. I can put the 2 of you into a breakout room and then move on to a different case while you're talking.
Thank you.
Mr. Seeger, were you ready on the Simpkins case?
I can be.
Okay, yeah, we can take that case early. Simpkin, if you can come up to the front there. Just 1 second. Mr. Hiddle, the breakout room's open, but you might have to press something to enter into it there. All right, so we'll go on the record in People versus Taylor Simpkin. This is file number 255034. The record should reflect Ms. Simpkin's present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of Plea.
Thomas Taylor, with on behalf of Ms. Simpkin.
This is the date and time set for sentencing in this matter. Ms. Simpkin, you had an opportunity to go through that report with Mr. Seeger. Okay. Mr. Seeger, are there any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this score?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, this is the case where we had offered a plea with the understanding that the defendant was eligible for 7411. I think the defendant has had some slip ups on bond, but she is a good candidate for 7411. I think that, given her age, given her education, given her lack of any real criminal history, guidelines are 0 to 3. I think everything favors giving her an opportunity at 7411 probation. And if she's successful, all the better. And if she's unsuccessful, well, we're right back here to deal with the consequences of her failure. So to my eyes, Your Honor, 7411 is a win-win for the people. So I would ask the court, even though she has had some issues with drug screens on bond, to still give her the opportunity on 7411.
Thank you. Mr. Seeger.
Likewise, Your Honor, I would just ask the court to consider giving her an opportunity at 7411. Clearly, this is a situation that she needs to rectify. Clearly, this is a situation where we don't want her coming back. So to the extent that she's able to successfully complete probation, that would be helpful to her and everyone else. So I would just ask the court to impose that as it stands.
Thank you. Ms. Simpkin, anything you wanted to say today?
Just that I want to assure you that I am trying to move forward with my life and do better. I'm receiving counseling for my mental health and the substance abuse issues, and just something that I'm embarrassed about and issue for. It's not going to happen again.
I did read through the report prior to the hearing today. I'm familiar with the circumstances of the charge here, as well as your background and your circumstances as well, based on the information in that report. And taking all of that into account, along with what you and the lawyers have had to say here today, I do think the recommendation is an appropriate way to move forward. And I'm going to follow that recommendation. I think it's absolutely appropriate to give you an opportunity, both through probation and through the 7411 statute, if you successfully complete it, to have this come off of your record. But I also think it's really, really important, based on what I read in the report, that you do follow through with any treatment, counseling, and prescribed medications that are recommended to you, because I think that's a really important key for you going forward. And I think this is a sign that this isn't something you can do just on your own. And so I hope that you take this as a sign that you need some help, at least for a while, with this. And if you do, I think moving forward, you can be successful. And all indications are that you could. So the court is going to sentence you to the probation as indicated for a period of 12 months pursuant to 7411. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report, which includes drug testing as directed by your agent, not using or possessing any controlled substances or paraphernalia unless they're prescribed to you, to only use your prescriptions as they're directed, and to avoid any police contacts. The court is going to sentence you to a period of 3 months. I'm going to hold that time in abeyance. So if you successfully complete your probation, you would never have to serve that time. However, if you violate your probation, you could be ordered to serve any or all of that time immediately. You do have credit for 2 days served. The court is going to impose a crime victims assessment of $130, court costs of $325, attorney fees of $350, a $68 state cost, DNA testing fee of $60, and a supervision fee of $30 per month while you're on probation. Because this is pursuant to 7411, there are no written appellate rights. Mr. Barrett, does she need to check in with you today? Or?
Yeah.
Oh, so just talk to Agent Barrett before you leave the court today, and good luck to you going forward. Thank you. Can you see if Mr. Connolly is ready with this client?
Sure, he's asked for 5 minutes.
Mr. Horowitz, are you able to hear me okay?
I can. Good morning.
Okay, good morning. We're on the record now in People versus Michael English, file number 244923 and 244925. This was set for a final status conference today. We do have a trial set to begin in 2 weeks, I believe June 17th, on one of the files. I know the parties have filed a stipulation in order to adjourn that trial date, but I left this hearing on today because I have not signed that order yet. Mr. English is not present. He was writted. I did see the Department of Corrections facility where he's lodged in the waiting room. We're running a little bit behind on the docket. They've since disconnected. I don't know if that's something that Department of Corrections did or Mr. English did. Mr. English has in the past voluntarily terminated his participation in the hearings before the court. So, but it's impossible for me to determine that. Nevertheless, I would like to discuss the adjournment. And I just want to make a clear record of it, primarily because Mr. English, Mr. Horowitz, as you're aware through you, has recently filed a motion regarding time limits in the case, which the court denied, but which make me hesitant to further adjourn any trial dates, even if they're at defense counsel's request, given Mr. English's difficulties with counsel. So I guess, Mr. Horowitz, I'd like you to make a record. I think the adjournment and the stipulation was arrived at your request. Is that right?
That's correct, Your Honor. I'm actually out of town right now. I'm beginning a murder trial out of town this Thursday. It's been a long time coming, and I expect that it will last for 2 or 3 weeks.
All right. Can you tell me the jurisdiction where that trial is at?
I'm in Fairbanks, Alaska.
Oh, okay. All right. I didn't realize. So you're licensed to practice in Alaska as well?
As well as New York.
Okay. All right. And Mr. Ziegler, you obviously don't have an objection. You stipulated to the adjournment.
That's correct, Your Honor. And after discussing this with Mr. Horowitz, I'm aware that he was going to be in trial for these dates. I don't have any objection to the adjournment being requested.
All right, so I guess what I had planned to address on the record today, Mr. Horowitz, was I was going to indicate that I was going to communicate with the trial judge. I was assuming that it was a Michigan case, maybe even, obviously not 46th Circuit, but a local Northern Michigan case. My intention was to communicate with the judge in your case and inform him of the status of this file or her to see if they would be willing to adjourn their trial so that our trial could go forward. Obviously, that's not gonna happen. And that's not a practical solution, given that you're already in Alaska. So for those reasons, the court will sign the stipulation and will reset Mr. English's trial. It's a one-day trial, so I anticipate the court can get a relatively quick date for that. And we'll proceed further as scheduled. Mr. Horowitz, anything else that I can address for yourself today?
No, Judge, but I appreciate you making the record. Thank you.
Ziegler?
Nothing further, Your Honor.
Okay. All right, thank you. Mr. Horowitz, you're free to disconnect at this time.
Thank you.
Back in. Mr. Hiddle, are you able to hear me?
Yes, I am.
All right, did you have, oh, I'm sorry. We'll take Mr. Connolly's case. Mr. Hiddle, we're gonna take another case, but we're just gonna keep you on the line here, all right?
Yes, sir.
All right, we'll call People versus Anthony Joe Lambert, file number 255020. The record should reflect Mr. Lambert's present here in the courtroom today, along with his counsel, Mr. Connolly. We have Ziegler here on behalf of the people. This is the date and time set for sentencing hearing. Mr. Lambert, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Connolly about that?
Yes, sir.
Mr. Connolly, are there any additions, deletions, or corrections to that?
Your Honor, just two additions, if I may. I've shown them to Mr. Ziegler. There's an ATS, a letter for addiction treatment services, indicating that my client's been approved for inpatient residential treatment. He also had an assessment done through Catholic Human Services while he was in the Wexford County Jail. There's a recommendation attached to that, if Your Honor would care to briefly view these documents.
Okay, sure, if you want to handle it. Connolly, did you want these attached to the PSI?
No, Your Honor, just for your review.
Thank you. Are there any other additions, deletions, or corrections?
None, Your Honor, thank you.
Any challenges to this morning?
No, Your Honor, thank you.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this morning?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, Mr. Lambert's before you today for his 33rd conviction. Suffice to say, his record is atrocious. He has 122 PRV points in this case. The grid tops out at 75 PRV points. He was also on parole for possession of meth, same offense he's being convicted of and sentenced for here today. He also admitted during the process of this case to law enforcement that he was going to deliver the meth in this case to someone else in Mansalona. Without belaboring Mr. Lambert's history, he's simply not a good candidate for community supervision in this case, Your Honor. He's well deserving of a prison commitment. The defendant was very forthcoming with law enforcement, which in my view is in his favor in this case. However, his record and his parole status militate against a lower sentence. I think the court would be perfectly justified in giving him the top end of the guidelines in this case, just based on his record and his parole status alone. However, given that he was relatively cooperative with law enforcement, I think a sentence of 18 months is fair, given his cooperation. So I would ask for that, Your Honor, 18 months consecutive to any parole violations.
Thank you, Mr. Connolly.
Thank you, Your Honor. And obviously, Your Honor, he does not get any credit for the time he sat, but there's a figure there. I believe it's at 122 days, Your Honor. I believe he sat. So I would ask that you take that into consideration. I know he's not due credit, but if you consider that in any sentence you might give. So this is the first time that I've met Mr. Lambert and interacted with him. He was with me straightforward and explained what happened and admitted responsibility for his actions right off the bat. So I was a little concerned when I saw his criminal history that he might be sort of somebody who was going to be difficult to deal with and not readily admit his conduct, but he did. He acknowledged that He knew better than to do what he did, that he shouldn't have been around the people he was around. We had some discussions, in fact, about his wife. He and his wife had quite the argument before him hanging out with these folks, saying, you know what's going to happen. You know what's going to happen if you're around them, and it did happen. So, and he acknowledged to me that by now he has to know better. He has to know better than to engage in this behavior. He has to know better than to be around people who are engaging in this type of behavior. Again, lengthy record, as Mr. Ziga pointed out. He spent a lot of time incarcerated over his life. He's almost the same age as I am, and I can't imagine spending that much time in jail and prison. So he knows what he can and cannot do and who he can and cannot be around. And I think he's gotten to the point now where he just has to make that choice. Like he explained to me in detail. He's like the things he's missed, the family things he's missed, why he engages in this behavior, sort of like, I don't know how it's akin to almost like being in school and having like what one of your peers say, oh, you should do this. And he just doesn't seem to have the ability to say no. He goes along with these things when he knows it's wrong and he knows that there's going to be repercussions. So essentially, until he gets it into his mind that he's no longer going to be around these folks or to engage in this behavior, he understands what the repercussions for his actions are. So he has written a statement to Your Honor. I explained to him if he's going to read a statement, to read it slowly and clearly so that he's not racing through it. But he is desirous, I should say, Your Honor, of remaining local if possible. He's on parole. I understand that complicates things even worse because it's a consecutive sentence. He's saying all the right things to me, Your Honor, and now it's time for him to start doing the right things. But that said, Your Honor, he understands there's a price to be paid for the conduct he engaged in.
All right, thank you. Mr. Lambert, anything you wanted to say?
Yes, sir. First off, I want to say, I want to be very, very candid with the whole entire scenario without sounding like I'm taking anything away from the things. Like when it was said that I was delivering something to Mansalone or whatever, when the police were arresting me or finding the stuff on me, I just did that. Oh, that's not mine. I was given it in payment for something that I did. I wasn't delivering it to anybody. I didn't know what I was going to do with it. I just received it. I didn't have a plan to deliver it to anybody. I probably would have at some point in time. So I'm not trying to say I'm not guilty of that, but I wasn't trafficking it as a planned thing to some person in Mansalona or anything like that. I just was trying to be like, it's not mine. I'm not in trouble. I didn't do that. And now it comes out like I was trafficking drugs as something, but I want to point that out that I wasn't doing that. I was just had drugs on me because somebody gave them to me for work that I did. Yes, I'm sorry. Your Honor, I feel so bad standing here in these circumstances. I feel like a big failure. I have let a lot of the people rooting for me down. My heart breaks as I constantly think about all of them. My wife, my children, my family, my parole officer, previous people I worked for and with, the Michigan Works people that helped me get funding to advance my career opportunities, the instructors of my trucking school, and my peers of all walks of life, everyone really. I'm very determined to be a success story. I don't want to waste the hopes and resources I have that have been invested into me. I feel sick fearing my actions have failed everyone. My actions have caused all hopes and well wishes and resources to be wasted so far. I have worked really hard gaining skills and abilities and certifications into my overall personal toolbox. I've also received a good amount of investment from others. I put a lot in jeopardy. A lot of hard work and investment I've accumulated over the last few years. Without your mercy, I have squandered most of that. It also seems like the easy answer to dealing with me when I cross the line is to lock me up. Not much is thought of the positive moments of my past. And a lot is focused on the worst moments, which makes sense being that I'm being judged over negative ones. They must not see much hope much hope for me and typically give me a sentence on the heavy side. The argument being, let's save the rest of us from having to deal with him for as long as possible. On paper, in this setting, I look like a bad guy. And sometimes I don't seem to be able to avoid being in trouble. Believe it or not, I have done a lot of work in counseling, understanding my issues with criminal thinking and curbing it. I really don't want to be a bad guy. My intentions right now was to be driving truck, weighing everything. It seemed like the perfect situation for me. I worked really hard to achieve that. I won't bore you with all the steps involved. Trust that it was quite extensive. And it felt, I felt proud. I was happy staying clean. All I had left to do was the behind the wheel and walk around exam for the Secretary of State. I had to wait a while to schedule that exam and got complacent with my overall life mission. My learner's permit is valid until October. I already have that exam paid for, but after October, all the efforts and resources have been squandered. All those efforts and resources have been squandered. I was looking forward to being a success, helpful to everybody rather than a drain. In the blink of an eye, my proclivity for criminal thinking has jeopardized all of that and a lot more. I feel so much shame over that. I really messed up. If you could please show me some mercy here, I will not take it for granted. I will try really hard to not squander everything. And I really do want to do and be good. Although I look bad on paper in this setting, I do honestly feel like I have a lot of redeeming qualities. I take pride in my work ethic. I'm a knowledgeable and capable person, and I care about other people. I constantly focus on being a helpful person. My issues with criminal thinking and behavior are unique as in anyone's, I guess. I do not feel that me being locked up a lot is helpful to me or anyone. I have sought out counseling for my unique circumstances. I believe further incarceration can further compound my problems and issues. I hope there is a way we can all work together on a success story. I'm currently doing counseling with Amy Cox through Catholic Human Services. Years ago, she worked with me and I sought out her help now. I feel like we have made some great gains in recognition of the true recognition of my issues. I tracked down the funding for this counseling through my insurance, and I also have funding for an inpatient stay through ATS. I offer an in-depth look at my counseling. I would feel good for me to sign a waiver for others to be able to see the details of my issues and my counseling in hopes that that knowledge could be helpful to others. I really do want to be and do good. I want the courts to see that and feel good about the path that I'm on. I know the chances of me not getting a prison term here are not in my favor. I know that the easy thing to do is say he crossed the line and these are the consequences. But if there was ever a time when someone was going to try to make something out of any mercy you're willing to show him, this is that time. It's not just something I'm saying. I really do want to do and be good. I honestly mean that. I had some.
Some of it's becoming repetitious, Your Honor. I'm just trying to continue to read through the whole thing, however.
Well, this is your time, Mr.
All right.
I can say whatever you want me to know.
Okay, I don't want to waste your guys' time, but
This is your time. This is an important hearing for you, and you have the right to speak.
I was trying hard. I got caught up in circumstances that in hindsight, I'm baffled I was so dumb to be involved in. In the moment, with my issues, somehow my criminal thinking did some sort of mental gymnastics to constitute being paid drugs as payment for work I rendered was acceptable. At first, I declined, but there was no money. At least it was something. I don't have the literary skill to describe how dumb I feel now. I know what's right and wrong, but somehow can still make criminal moves when I have no intentions on being that guy. My wife and I even fought about whether I should go over there or not because we were aware of the criminal element. I understand. I ultimately overruled her concerns needing the money and I was supposed to make putting furniture together, telling her I don't have to worry about anything because I'm not doing anything wrong. Then for some reason there was no money, but offered a greater value if I accepted payment in drugs. She was so right, and I have failed in ways that genuinely sickens me. When I think deep about it, I'm so disappointed in myself, that it's crushing. It's hard to explain and understand like this. That is why I offer the details of my counseling efforts. I understand that life will always challenge me with these sorts of situations, and I need to be a better developed person. I like to view myself as a valuable and helpful person to have around. I don't want to be a drain or hurtful to society and the people I love, and the people that I love and the people that love me could really use my help rather than having to help me. I really want to live a life where I'm proud of myself and people are proud to know me instead of ashamed. I have just a little bit more. I don't want you to feel like wait, is it okay?
Again, this is your time. I want to hear whatever it is that you want.
Being housed in Wexford County, I've seen Wexford County do a program where they do a bond and defer sentencing until after treatment or some proving tribulation. Good performance possibly earning favorable consideration, and poor performance possibly earning doom. When they reconvene the sentencing after the events transpire. I understand there is no program like that set up here, and my parole circumstances make things tricky to deal with through a probation standpoint. But please, if there is any way we can think outside of the box and be creative about this, please help me. Please see I'm not a lost cause. I made the most out of the last prison sentence you gave me. I achieved a lot while I was there. I probably set the record for achievements while I was at Vocational Village. I messed up. I made unfathomable mistakes. I'm very sorry I messed up so bad. I truly mean that. I feel so bad. I have been a horrible husband, father, son, brother, friend, person. My community has suffered over my actions. I feel so bad. It really hurts right now. I don't even know how to describe the shame I feel. I'm very humble. I'm going to be a success story. My prison isn't going to be helpful to me or the people around me right now. Please help me. I really do want to be a person people are proud of. Perhaps we can figure out some sort of jail sentence where I can work and have the opportunity to prove myself and not waste all the work and resources already invested. I also can continue the productive counseling I've been working on. Please give me some chance and I will try so hard to make good and act like a smarter person. There has to be something else we can try besides more prison, something productive. I really wish to be a productive member of society. Please see the good person I want to be and help with a positive alternative. I'm going to act smarter no matter what. There has to be a better way. I know I'm wrong. This failure is surprising to me. This has been incredibly humbling. Thank you for hearing me out. Sincerely, Anthony Lambert.
All right, thank you.
Sorry about the length of that.
Well, there's nothing to apologize for, and that's information that's important for me to know. I think a lot of times it's important for you to say some of those things in public out loud.
My family's here too, so they get to hear me say that.
Right. So that's why I don't want to cut you short, because there are things that you need to say and should say, and not just for my benefit, but for your own benefit and the benefit of your family, as you said. So there's no reason to apologize. And I listened to everything that you had to say.
Thank you.
I read through the report, of course. I'm familiar with the circumstances here, I'm familiar with your background and your circumstances. We all know what's gone on before. Prosecutor pointed it out. You've had 16 prior jail sentences, you've had 3 prior prison sentences. You've been on probation 7 times. And so, all of that, it does play a role in the court's consideration. And I think you're completely sincere. You appear to be very sincere to me in your statement. A lot of the things you said don't sound like the things that people say just as a way to get sympathy. And I think, everybody gets to a point in their life where they're sick of doing what they've been doing when it hasn't brought them good results. And I think at your age, you're getting to that point where you just don't want to do this anymore. And a lot of times that's what it takes for people to make a change. And it concerns me when people talk about the court or the system thinking that there's no hope for rehabilitation, because I don't think that's not the way I look at it as a judge. I think people can be rehabilitated at any time in their life, particularly when the problem deals with drugs. People have very long journeys to recovery sometimes, and they involve lots of twists and turns that are not good. But I don't think anybody's ever passed rehabilitation. The question for me as a judge is whether or not to continue to commit community resources towards that rehabilitation, or whether as the court, we say, all right, he's been on probation 7 times, parole however many times, continuing to reoffend. At some point, we're just not going to put community resources towards your rehabilitation. But that doesn't mean you can't be rehabilitated, and that doesn't mean that you can't do it for yourself without the court ordering it. As you've indicated, you've investigated that, through insurance, through other things, there's ways to get help on your own outside of the order of a court. And so I think you can move on from this. I think you have the capacity to do that. I think based on what you said, you have the desire to do that. And I think what remains to be seen is what you do to get to that point. But at this point, from the court standpoint, I would not be justified in continuing to give you opportunities through local penalties and probation, because it hasn't been successful. In this case, you were on parole. I mean, if there's ever a time to be following everything to a T and not do the kind of things that you were doing, being on parole is that time. And here we are, and I don't have anything to go on to say, if I put you on probation here, that it's going to be any different.
I was doing a lot of good while it was up.
And I'm saying you weren't, but what I'm saying is this still happened while you were on parole. And so from that standpoint, it just, there's no justification for the court to put you on probation here, or a local sentence. So I think an appropriate penalty, for the reasons I've stated, is a Department of Corrections sanction. I think there is room for mitigation for the reasons indicated by Mr. Ziegler. I think an 18-month sentence is appropriate. It accounts for your conduct in this case. It's justified by your past history and your parole status at the time that this occurred. The court is going to sentence you to 18 months to 10 years in the Michigan Department of Corrections. You have credit for 0 time served based on your parole status. The court is going to order that sentence be served as required by statute, consecutive to parole. A crime victim's assessment of $130, court cost of $350, and a $68 state cost. You do have the ability to seek an appeal of the sentence, and Mr. Connolly, have the appellate rights there. You can have.
Yes, right. So you want to appeal your sentence, you have 6 months from today's date, okay? You'd have to turn this form in either to the Department of Corrections, jail, 6 months in, yeah. Today's date. Your Honor, do you want him to, just one copy for the court's records and the rest for Mr. Lambert, or how do you?
Yes, the highlighted one.
Highlighted one's yours, Scott. All right, thank you, Your Honor. Mr. Lambert has initialed and dated his notice of appellate's rights form. I've advised him he has 6 months' time in which to act if he wishes to appeal. And I have the original copy for Your Honor's clerk.
All right, thank you. Good luck to you going forward. Mr. Travis, are you ready to proceed with Mr. Hill's files?
I believe so, Your Honor. I do have a case information to give Mr. Hill that I just have to talk to Mr. Ziegler about.
Okay.
I talked to Mr. Ziegler. He had indicated that if the cases are resolved, he would dismiss both those misdemeanors today, so long as restitution is preserved.
So then no contact to be lifted.
Once they're dismissed, there is no contact.
So that would end today.
Probably tomorrow, because he's got to dismiss them and they've got to get signed. But yes, he would dismiss those cases.
Okay, we'll go ahead and plead then.
Okay.
All right, so just for the record, the charges are the same, correct, that he's pleading to?
That's correct, Your Honor. The only difference is the timing of the nollies on certain cases.
Okay.
There's a number of misdemeanors that were going to be dismissed as part of this. There's a no contact in place between Mr. Hiddle and his wife, and if they didn't get dismissed soon, that would just continue.
Sure, okay. So, Mr. Hiddle, is it your desire to go forward with this plea agreement as we've previously stated?
Yes, sir.
Can you raise your right hand, please? Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Hiddle, are you currently on any kind of probation or parole?
No.
You understand that you're pleading guilty to 2 counts of resisting or obstructing a police officer. Those carry with them each a maximum possible penalty of up to 2 years and or a $2,000 fine. Do you understand that?
Yes, sir.
With that maximum possible penalty in mind, what is your plea to each of those charges today?
I plead guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making today. The only way you can appeal it is by leave, and that means that you have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've discussed here on the record today?
No, just that the files with the no contact to be lifted for I can have contact with my wife.
Okay. Is it your own free choice to enter these pleas?
Yes.
Are you pleading guilty because you are actually guilty of each of these charges?
Yeah.
All right, so I'm going to talk about the older case. This is the one that goes all the way back to 2020, April 22nd of 2020. Do you recall the interaction with police on that day?
Yes, I do.
All right, did that interaction occur here in Kalkaska County?
Yes, sir.
Did that involve Sergeant Paul Bellinger of the Kalkaska County Sheriff's Department?
Yes.
And when you encountered Sergeant Bellinger that day, were you aware that he was a police officer?
No, I was not. It was dark and I had problems with my sister's boyfriend, and that's actually that he identified himself after he ran.
Was he wearing a uniform?
Yes, but it was pure dark.
All right, so you couldn't see that he was a police officer at the time that you were interacting with him?
No, I could not. Not until I already done ran and he said police.
All right, so after the time that you knew he was a police officer, What did you do to resist or obstruct him in his duties?
I hid out of fear.
I couldn't understand.
He hid out of fear.
Okay, all right, so you knew that Sergeant Bellinger was there to perform his duties as a police officer by that time, and you did not comply with his commands and you hid from him, is that correct?
Yes, sir.
Okay. As to that charge, Mr. Ziegler, are you satisfied with the factual basis?
I'm satisfied.
Okay. So, Mr. Hiddle, the second incident that I'd like to discuss is more recent. That's from March 28th of this year, 2025. Do you recall that incident?
Yes, sir.
And on that date, did you also come into contact with a deputy from Kalkaska County?
Yes.
Did you know that that deputy was there to perform his duties as a police officer?
Yes, sir, I did.
And what did you do to resist or obstruct him in his duties at that time?
I ran and hid.
Okay. And did that occur here in Kalkaska County?
Yes.
All right, as to that charge, Mr. Ziegler?
I'm satisfied.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
Nothing other than what's been placed on the record.
Okay, and Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in taking up this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Hiddle, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these counts. The court will accept your guilty plea as to full. We'll set this matter for a sentencing hearing. Between now and then, somebody from the probation department will be in touch with you to prepare a pre-sentence report. And you'll have an opportunity to go through that with your attorney before the sentencing hearing. Mr. Travis, anything further today?
I don't believe so. Mr. Hiddle, anything further?
Just what we talked about on the meeting, if you want to bring that up, that's fine.
I couldn't hear that, Mr. Hiddle.
Just if you want to bring up what we talked about on the meeting, but if not, it's fine. That's all.
Okay, we'll leave it as it is.
Okay. Thank you, Mr. Hiddle. That's all for today, and the court is going to disconnect at this time.
Thank you.
Ms. Leach, do we have our defendant ready in your case? What's his name?
Mr. Fox.
What is it?
Is it Fox?
Fox. Is that what it is?
Yes, Mr. Fox.
Okay, good.
This is a 1, 2, 0, 4, pass. Fox, I'm gonna have you go right to that podium right there. Yes. We're on the record in, who's the plaintiff in this case?
Melissa Hurd, I brought the people.
Okay, great, you get a photo of that, please. Name's Darren Fox.
Yes, sir.
Okay, so this is Melissa Hurd versus Darren Fox, file number 1211044. I'm conducting this hearing on behalf of Judge Boudet. Mr. Fox is present here in the courtroom today. Mr. Fox, you're before the court today because you were arrested on a warrant for a failure to pay child support. Do you understand why you're before the court today?
Yes, sir.
Okay. We have Ms. Leach present on behalf of the front of the court. Ms. Leach, can you tell me what the front of the court is asking the court to do here today in this case?
To give you a little bit of background, Mr. Fox has a monthly obligation of $482 plus $100 ordered on arrears for a total of $582 per month. His arrears on this case are $7,180.44. We had received an involuntary payment in May of $525, $50 in March, and $200 in February. We've had multiple show causes from the referee on this case. Just going kind of back to January. At that hearing on January 10th, He had stated that he was door dashing under his wife's name, and claimed that he had only was helping her at the
Can
time.
I interrupt, please?
I'm gonna give you a chance. to-
I just wanted to correct that, but
You'll have an opportunity to tell me what is wrong.
The referee at that time was trying to work with him. She allowed reduced payments of $200 by January 31st and then $200 by February 28th, which he did make those payments, but then stated he would need to start making his full payments in March. In March, he only paid $50. Since then, he has not paid anything since then. In April, we had another show cause. He had stated that he was starting a new job doing construction on 4/7 and that it would be a full-time job. He was ordered to make payments of $532 by April 21st, which would have been the balance of March. We did not receive anything. He was ordered to make another payment of $200 by April 30th, and then $964 by May 31st, which would have been the balance of April and May, and then full payments in June going forward again. He failed to appear at the May 16th show cause, and the referee did order the bench warrant. I did have a chance to speak to him a little bit on the phone yesterday. He kind of goes back and forth. He started off by telling me that he's having vehicle issues, that his boss has been helping him, and getting him a vehicle to drive, but then he had a vehicle that he was driving, it had plates and insurance when he was pulled over and got arrested. But then later in the conversation, he told me that he's not working and that he's trying to get disability. When I questioned him on that, because he kept mentioning his boss, he said, well, he's only doing a roof for a friend. So I'm not really sure. We've had conversations and it's been placed on the record in the courtroom that he is working. I'm not really sure what is going on at this point. At this point, I don't know what more to do with him. The referee has really tried to work with him. She's given him the chance to make reduced payments, trying to give him a job, trying to get him out there making his payments. I mean, I know he was in prison, but he was released from prison back in April of 2024. So he's had a lot of time to.
I also went back to, sorry.
To try to, get going on this. So at this point, the front of the court would just be recommending the 45 days in the county jail. That would be his first finding of contempt, and just leaving the bond where the referee had ordered, and it was at $2,000. That included $100 bench cost.
Mr. Fox, can you raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. All right, Mr. Fox, what was incorrect about what Ms. Leach just
Okay.
said?
First and foremost, you spoke on the DoorDash issue. My wife has a DoorDash account. I'm not allowed to in any legal way, shape, or form DoorDashing under her account. They lowered my payments at that moment in time because I had 2 surgeries on my hand. Carpal surgery could not work at all, period, none whatsoever. Gave them the doctor notes saying this. They reduced my payments, which I was able to make and reduce state, And I was supposed to get another job. I had a job lined up. It went to shit. First day, sorry, I didn't mean to curse. It didn't work out. I didn't have a job. My friend helped me, or he did reach out to me, stays on Caliber. I was going out there daily to help him work on a roof. We had probably 4 more days worth of work on this roof when we were getting paid. He gave me $300 last night, hoping that maybe I can help get out and then get paid on Friday, Saturday. If I get out, help make the rest of this money. And then I can help make a little, Your Honor, I'm confused.
What are you confused about?
Just everything,
Okay, you can't be confused about everything.
I mean, like.
Nobody's confused about everything.
She asked me last night, what could I afford to come up with today?
Yeah, okay.
Today, I come up with $300 and I come up with another $500 Friday or Saturday.
Okay.
I would never, in no way, shape, or form, be able to come up with the 2,000. If I go to jail for 45 days, that just sets me back behind even more. I understand the frustration with the courts and my frustration. I was driving a car with no insurance, no plates and shit like that, trying to get back and forth to work that I got from my boss. You know what I'm saying? So the other car I had went out on me again. I wrecked my other truck back in February, and it's one unfortunate. I'm trying, man. That's all I can say.
All right. Aside from the
my disability, sorry, I didn't mean to cut you off. Disability thing. I've been speaking with my psychiatrist. I've filled out numerous job applications. so many, it's frustrating. I've had interviews, I've been denied jobs because of my lack of work history. My mental health is taking an impact on this, and so me and my psychiatrist talk. She's trying to put in for me to receive. She's starting the process of disability, and in the meantime, I'm doing odd jobs to try to make a few dollars here and there to possibly be able to make payments toward this.
Okay.
But I can't do it in jail. I understand the recommending the jail. I appreciate it. Maybe I can come up with 300 now and then 500 Friday or Saturday to help avoid jail. I don't know, but
Okay.
I'm trying, man. I just got off parole. Like, I've done a lot of good stuff in my life.
All right.
I'm working on a lot of things.
So aside from the DoorDash thing, in terms of the payments, is there anything incorrect about what you said in terms of what you paid and haven't paid over the last 5 months?
No, I've paid, they took all the taxes that I had when I filed my taxes. They put that all toward that. I made a $50 payment. That's all I could afford at that point in time. You know what I'm saying? They wanted 500 or something. Your Honor, I haven't had a job in over a year. Yes, I've been out since, I forget what day she said I got out of prison, but I also went back to prison. I also had a lot of, incidents where I went back and forth to jail. I had to do detainers and all this extra stuff that, I had to get myself corrected on.
Okay.
And
All right, here's what we're gonna do. All right. First of all, I find that there is a failure to exercise due diligence to make the payments as were agreed to. So the court finds there is a basis to hold you in contempt. And so the court is gonna find you in contempt. I'm gonna impose the 45 days in jail. I am gonna allow you to be released at the time you make that $300 payment. The court will also order that you make a $500 payment by June 14th. So I'm gonna give you a little more time than even what you're saying you can do it in.
not to cut you off, but so I have an understanding. So if I pay $300 a day,
Yeah.
I can get out and work toward making this happen.
Yep.
Okay.
So, but I want you to, let me finish saying everything I'm gonna say, and then I'll see if you have any questions.
I got you.
So I'm ordering that you serve 45 days in the Kalkaska County Jail with credit for, was you arrested today or yesterday?
Yeah.
Someday.
With credit for 2 days served, then if you're arrested Sunday, whatever day you were arrested, with credit for your time served. The court will allow you to be released upon a $300 payment. The court will order that $500 payment be made by June 14th. So that's a week from Friday. If those payments are made, the court will hold the remainder of that sentence in abeyance. And again, you'll be released upon the $300 payment. If you don't make the $300 payment, you're here until that $300 payment is made.
Understood.
If you're released with the $300 payment, if you don't make the $500 payment by the 14th, the bench warrant will be issued and you'll have to serve the remainder of that 45 days. If you do make that $500 payment, the court will set this for another hearing before, would it be before the referee,
It'll be before Judge Day.
before Judge Boudet, to monitor. So do you have any questions about that setup?
I feel it's fair, sir.
Okay.
So
All right.
if you guys allow me to do that, I'll make what I gotta do.
Okay. And Ms. Leach, if you can prepare that order, I'll sign that whenever that's ready.
And just so I understand, $300 today, 500 by June 14th, credit for any time served. If he doesn't make those two payments, we would reissue the bench warrant. Would that be an ex parte bench warrant at that point?
Yeah.
And would we read the purge amount at the original $2,000?
Minus whatever amounts are paid.
Okay. And then if he does make those payments, we'll have it.
Yes. Okay. All right, thank you.
All right. Thank you, sir.
Do you need these back or these copies?
Bring it back up.
And then we're gonna recall Mr. Way's matter. I'm gonna take a short break before we do that and back on the right. We're back on the record. This is People versus Scott Way. We had started this hearing earlier, had to take a break, and now we're resuming the hearing. So, Mr. Travis, I think, and I know we're going to argue about the variables in a minute, but your request is for the court to alter the body of the PSI to take out the information that the defendant believed he was interacting with a female who was 12, not that he was interacting with a female. Is that fair?
Correct. It was the age was my
Specific. All right, Mr. Sigler.
Your Honor, I guess to the extent the defense is just saying what the defendant did or did not believe, I guess I don't really care. But the point here is that early on in the conversations, this individual identifies themselves as a 12-year-old. And the issue that Mr. Travis and I are having, in fairness, is that this is the collection of text messages that we received. They were not in order. So we know that because the first text message on the stack is from, I believe, Telegram, and it says, "Hi, who this?" And it says, "It's Ari. Why did you stop talking to me on Instagram?" So clearly, the Instagram messages in here came before these, and they're not well ordered. But the first message, at least what I'm alleging is the first message, is the one that starts with, says Scott at the top, it gives his name at the top, says view profile, so this would be the first message in the thread. And it says, "Hello, thanks for the follow." The predator poacher guy says, "Hi, I'm Ari." They discuss living in Ohio, and then it ends with "where in Ohio" on the bottom of this page. But I believe the second page to be is this page, and it starts with, "Whoa, I'm in Miamisburg, haha, that's crazy." And then on that page, it says, she asks, "How old are you?" "I'm 23. And she replies, "Oh, I'm 12, LOLs." So by my reading of these messages very early in their conversation on Instagram, this person identifies themselves as a 12-year-old girl. And clearly they're looking at an Instagram profile where they're fake photographs. They then go on to discuss him seeking nude photographs from her in various forms. So regardless of how Mr. Travis wants to slice it, whether the explicit requests for nude photographs are in the Instagram messages or later on when they move the conversation to Telegram, doesn't really matter, because again, she's established it's Ari, why'd you stop talking to me over here? It's clearly the same persona that he's interacting with, and the same persona that's already identified themselves as a 12-year-old girl. So if the court wants to amend the language to not Mr. Wade believed she was 12, but the individual identified themselves as 12, I would have no objection. But clearly there's a factual basis for her identifying herself as a 12-year-old.
Okay, that I agree with. I guess then the other question is when, and did he request the nude photos after that point? Is that your argument, Mr. Travis?
Yeah, so that becomes the confusing part of this because of the correlation.
Okay, so let's, I just want to compartmentalize this, so I'm only dealing with one issue at a time. So in terms of the report and the section you identified, Mr. Travis, I think a fair correction would be he was engaging in a long text conversation between Snapchat and Telegram with someone who at one point identified themselves as being 12 years old. And that's the correction that the court will make. Let's see where we go. Let's just deal with any other corrections, additions, or deletions. Are there any more of those?
No, Your Honor, and I guess that is the court's correction. I would note one other piece of this that further confuses it is, I believe from reviewing these, there's also conversations where this predator hunter individual, I think, and this is tough to determine, we never had a prelim on this, I don't really know, but there's texts that appear to be from another adult talking about pictures with Mr. Way, who is not allegedly this Ari person, to further confuse this massive text messages. So not that that necessarily does it, but just to kind of give a little more context
Okay.
to this.
All right. All right, are there any more corrections, additions, or deletions to the body of the report?
Not that I'm aware of, Your Honor.
Are there any challenges to the scoring guidelines?
Not from the defense.
Okay. Mr. Ziegler, we'll address your scoring, but are there any corrections that you want?
No additions, deletions, or corrections, Your Honor.
So I had a chance to review your memo regarding the scoring. So we can just make a record of what you're alleging is a correct scoring and then how that affects the guidelines.
Certainly, Your Honor. So the challenges relate to OV 12 and OV 13. And essentially the issue between Mr. Travis and I boils down to what counts as things being scored under OV 12. My view is that you score, well, you start by scoring OV 11 according to People versus Beamer. That doesn't apply here. Then you score OV 12, and my view of it is you find whatever the maximum score the facts support, and if there are 3 or more, you score the maximum amount. So in this case, all of the crimes involved here are crimes against a person. There were 8 charged. There could have been 200 charged, 110 for each file and 110 using a computer. So be that as it may, the maximum score allowable under OV 12 is for 3 or more crimes against a person. And clearly, in this case, that 3 or more threshold is exhausted. Then Beamer instructs you can move on to OV 13 and you can score whatever remains in OV 13. So because there are so many offenses that are left over, I think the court is required to score the maximum under each OV. So if you can only score 3 under OV 12, you have to score the rest under OV 13. Now, Mr. Travis's position is the language in the OV 12 that says 3 or more means that that is essentially an infinite bucket, that you can dump as many things that fit under OV 12 as possible into that bucket, and that bucket never gets exhausted. And then when you move on to OV 13, your offense bucket of things you have left to dump into OV 13 is empty. I don't see that that's the case. The way we discuss scoring OV 12 or any OV really is we talk about what offenses or what acts get us to the maximum score. And then when there's more conduct than that, we talk about departures and we talk about unscored conduct or unscored offenses, meaning that they're not encapsulated by the scoring of those variables. So my view is you take your bucket of offenses or bad acts, you start by dumping into OV 11, but you can only fill it up to the maximum. You can't keep filling it infinitely. At some point, you cap out on points. You can't keep filling it. You go to the next one. You can go to OV 12. Does anything left over fit into OV 12? Well, only 3 more. And then you can't score anymore in OV 12. You just can't. It stops at 25. Then the court is required to score the maximum in OV 13. So you still have a bucket left. You keep dumping into OV 13 until that's full. Now, as an alternative, I've argued that these offenses are continuing offenses, and so they extend outside of the 24-hour period contemplated by OV 12. So therefore, in my view, that because they extend beyond the 24-hour period, you could still score them in OV 13. Finally, I allege, even if you ignore everything that could possibly be scored in OV 12, let's just assume Mr. Travis is correct. We dump everything within 24 hours, everything that's allowable under OV 12 into the OV 12 bucket. It's an infinite bucket. There's nothing left. Then we go to OV 13 and say, is there anything left that we could not have put in OV 12 that we can still score in OV 13? And my view is the answer is yes in this case, because of the accosting, because of the using the computer to commit the accosting, and because the sentencing offense itself cannot be scored in OV 12. It can't be contemporaneous with itself, but it can be scored under OV 13. And therefore, even if Mr. Travis is correct on his argument about the infinite bucket of OV 12, you still have 3 offenses you can score in OV 13. So I think, I don't think there's any reasonable argument that OV 12 should not be scored at 25 points. There's clearly 3 or more contemporaneous felonies against a person. The only question is how to score OV 13. I think that anything you don't put to 12 can be put to 13. Even if you disagree, I think the fact that they extend beyond the 24 hours means they can be scored in OV 13. And even if you disagree, I think we have 3 offenses outside of all of that. They can be scored.
So what, following your argument that OB 12 isn't an infinite bucket, to use your term, then why would the legislature use the word 3 or more instead of just 3?
I think because the legislature would have contemplated that there would have been more, and it would have been ambiguous if they hadn't said 3 or more. Because then the question would arise, what if there's 4, what if there's 5? But
Isn't the answer then they would just be scored under OB 13 then?
well, I think either way it's scoreable under OB 13. I don't think the legislature's grammatical inclusion of 3 or more versus just 3 really changes what the courts have decided the process is for scoring those OVs. And the court in Beamer has explicitly said the legislature's intent was to prevent multiple scorings for the same conduct. It's silent about multiple offenses, which is what we have here. And the court in Beamer says you score 11, anything left over, you score 12, anything left over, you score 13.
Okay. Thank you, Mr. Travis.
Thank you, Your Honor. And Mr. Ziggers largely pointed out my argument, and my argument basically comes from a plain reading of the sentencing guidelines. It discusses 3 or more. It discusses what is a contemporaneous act, something that occurred within 24 hours and will not result in a conviction. The Bremer case, I would argue, kind of resolves this. Everything that can be scored in 12 must be scored in 12. And the guidelines in numerous instances top out. It's quite common in the guidelines to just have certain things be that's where it ends. You know, number of victims, it's replete throughout the guidelines that we get to a certain threshold of assessing points, and that's what's assessed. The other thing I would note is both the 2 cases kind of that even touch on this, neither of them do what Mr. Ziegler is arguing. In neither instance where this is addressed, in both of those cases, under Mr. Ziegler's theory, one of the cases specifically is a CSAM case, where there's hundreds of images. And the court's interpretation, because the argument is, are they contemporaneous or are they not? And the court in their ruling says, well, even if they weren't contemporaneous, well, then they could have been scored in 13. So it doesn't, they kind of call it a wash and say, well, it would have been 25 points there or 25 points in 13. They never say it would have been 50 points in a similar case with hundreds of images. So I would argue, not that conventional practice or conventional scoring, it holds the court, but that's what the courts have been doing. That's what MDOC has been doing. That is the conventional reading of the sentencing guidelines, is that we top out. Because as Your Honor pointed out, it says or more, which would not designate that. And then we move to 13. 13 is arguably a different situation. It's a continuing pattern of criminal behavior. It's got a 5-year window. Many times there's other acts that could be charged. Even if you had 100 crimes in 12 and they were maxed out, many people come before Your Honor with a history of crimes. Mr. Way is different in that he comes with no criminal history. I would also note that the prosecutor charged all these crimes in the same day. He didn't charge them on different days. This is a one date complaint. So, I mean, I don't think necessarily the prosecutor is trying to argue that they're not contemporaneous crimes. The kind of bigger picture that he says, oh, well, they're all continuous. That's just not how the courts have generally dealt with this. That's kind of addressed in the Lobdell case. I'm sorry, that's not right. But in the other case on point, it talks about how, well, maybe it could be, maybe it couldn't be, maybe you argue that. But under Mr. Ziegler's theory, then theoretically one piece of CSAM could be 100 counts, because every day is a possession of CSAM charge that someone has it on their computer. And I don't think anyone's saying that that's really how these cases should be charged, that it's a continuing and forever situation. So I think a plain and appropriate reading of the guidelines would say score all contemporaneous crimes over OB 12. Score any other continuing pattern crimes under OB 13. And I just don't think the argument, well, then they're continuous, so what I don't use in 12, I can use in 13. I just don't think it's an appropriate reading of the instructions. I definitely don't think it's what other courts are doing. It's what the interpretation is. I think the prosecutor is asking you to basically make novel law. At least as I see it, because there isn't any case law, and what case law there is doesn't address doing things the way he's asking the court to do.
Okay. All right. I did have a chance to review the prosecutor's memorandum prior to the hearing today, as well as the language of OB 12 and OB 13. One of the primary rules of statutory construction is that they're to give the language of the statute its plain ordinary meaning, and not to give an interpretation that would render any of the language meaningless. And in this case, it's a really interesting analogy, Mr. Ziegler, a good analogy, I think, of the buckets, and you fill up OB 11, and then you move to OB 12 and OB 13. I think that's an interesting way of viewing those. I just don't agree with it in the context of this case. Again, I look to the language of OB 12, which does use the words 3 or more, which contemplates that it could be 3, 4, 5, 6, 10, 12. The legislature did not put a limit on that. And so the court has to interpret that in a way that gives meaning to those words 3 or more. So I don't find that in the context of this case, an interpretation that you score up to 3, and if there's any left, then you can pile those under OB 13. I also look at the purpose of the different variables, and I think in practical application, sometimes there is that overflow kind of effect between OB 11, 12, and 13, but they're clearly meant to score different types of conduct. Otherwise, OB 13 would say something like, anything would use that kind of overflow type language, but it's meant to score different types of conduct that, in my view, wouldn't be scoreable under OB 12 on the basis of the facts, not on the basis of the number of instances. So I agree with the defense argument, and the court's going to deny the prosecutor's objection to the scoring of OB 13 at 0. And the court finds that regardless of the number of incidents, they're all contemporaneous acts, they're all scoreable under OB 12, and the legislature's made a specific decision that once you get beyond 3, you simply can't get more punitive than the 25 points. So at that point, they just become cumulative. So the court will order that the scoring remain the same and the guidelines remain 15 to 25. Mr. Ziegler, did you have any other objections to the scoring?
No, Your Honor.
I do want to make a record, and I'm not sure if I did that before. Did you want these letters attached to the PSI, Mr. Travis?
Yes, Your Honor, thank you.
Okay, and I did have a chance to read those. Mr. Ziegler, do you have any victims that wish to address the board today?
No, Your Honor.
Anything on behalf of the people for allocution?
It's a difficult case for me. On the one hand, the defendant presents on his first felony offense, demonstrating appropriate remorse, and seems a good candidate for efforts towards rehabilitation. On the other hand, his conduct in this case is simply inexcusable. The defendant possessed 76 images and 34 videos of child sexually abusive material. And to make matters worse, he was actively seeking it out by soliciting someone posing as a 12-year-old girl for nude photographs. While it may be the case that no one was actually directly victimized in this case, because it was not actually a 12-year-old girl, it seems the defendant is perfectly willing to victimize young girls and was actively seeking to victimize them online. I did have occasion during the plea negotiation process to review the assessment that's attached to the PSI. I find the assessor's opinion in this case simply remarkable. The assessor is plainly aware of the allegations in this case, both the possession of CSAM allegations and the accosting conduct that the defendant allegedly engaged in. However, the assessor concludes that the defendant has, quote, no sexual interest in anyone other than pubescent adults. I find that starkly in contrast with the facts of this case, especially in light of the defendant's plea, Your Honor. It's one thing for the assessor to say that the defendant is a low risk to reoffend with appropriate intervention. I have no issue if that's his conclusion, but it's entirely another thing to conclude that he never really had any sexual interest in children in the first place, when he was actually soliciting someone he believed was a 12-year-old girl for photographs. That conclusion just boggles my mind. I can only assume the assessor means when he says that the defendant has no interest in actually engaging in sexual acts with a particular minor. But that's hardly the point of the assessment, is to determine whether he's likely to go out and commit more serious crimes in the future. The question is whether he's likely to be rehabilitated and whether he's likely to reoffend in the way he is already offended. So I don't put a lot of weight on the assessment for those reasons. The operative question here is whether the defendant is likely to reoffend in the nature he is already offended, namely the possession of child sexually abusive material and the soliciting a minor. So I don't know what the assessor would make of that question. I don't read his assessment in that way. What I do know is that the legislature has provided for very harsh punishments for possession of CSAM, and they've done so for a good reason. People who possess child sexually abusive material indirectly create a demand for its production, and that leads to children all over the world being victimized. The legislature has determined that severe punishments for possession of those materials will help deter creation and promotion and distribution of child sexually abusive material and protect children. The goals of punishment, rehabilitation, and deterrence are not mutually exclusive in this case, meaning the defendant can work towards rehabilitation while still being punished appropriately and while still providing a deterrent effect to other members of the community. The guidelines are presumptively reasonable, and in this case at 15 to 25, they do call for a prison sanction. The court's sentence can be on the lower or middle end of those guidelines and still meaningfully accomplish all of the goals of sentencing. I do not believe there is any justification in this case for a downward departure. The defendant engaged in criminal behavior that everyone knows, everyone in their right mind must know, is a serious felony offense. And now he must accept the consequences of that behavior. I would ask the court to sentence the defendant to 20 months.
Mr. Travis.
Thank you, Your Honor. Your Honor, as the prosecutors noted, it is a PSI notes, Mr. Wade. This is his first criminal conviction. Obviously, it's a fairly serious one. I think what is quite notable is that Mr. Wade wants to be better. Even in how all this happened with the predator hunter individual, when they first interact, Mr. Wade is very giving and telling, and even hands him his phone. And part of that is because, you know, I think he believes that this gentleman is gonna help him and not help get him more of this type of stuff, but he's gonna help him. And maybe in a broader sense he is, but Mr. Wade was very forthright with him because he knew this wasn't right. He knew this wasn't good. And he's continued to be that way. The biggest thing with the assessment that, you know, Mr. Wade took from it is, and he was practically gleeful that he wasn't doomed to be the type of person that is projected here. It made him happy to know that there was hope, that this wasn't this wasn't what it was gonna be. I understand the prosecutor's, issues with the assessment, but I can definitely say in speaking with Mr. Way, it just made him in our discussion so happy to basically not know that this was who he was. That he could, and as he's indicated in the PSI, that he can be productive, that he can not be the type of person who's going down this road. So I think there is all along this case, there's been a great desire to productively move forward, to helpfully move forward, to do what he needs to do, to not be the type of person doing this type of behavior. Thank you.
Mr. White, anything you wanted to say today?
Mr. Travis is right. And I did hear that report about him. Sorry. About being said I was a good person. I was so happy because no one ever sees me as a good person. And having a professional, I guess, psychiatrist or something telling me that, it just made me feel better. And I do want to get back out in the world. I have just been like cooped up home because of fear of fear of going outside, being seen with anybody, because a video was posted in town about me talking to that guy, and I did think he was there to help me. He even said he'd give me a pamphlet or something, but it just went straight to the police. But when they did show up, I was completely candid with them and gave them everything, passwords, phone, anything they needed. I'm sorry that even though the prosecutor said no one was actually hurt from this, I still feel like people were, mainly my family, everybody that considers me a friend. Because I'm not a monster, I'm not a pedophile, I don't go actively looking for people. I just want to get back out in society and get a job and pay back these bills. Sitting at home just waiting, it's killing me. That's all, Your Honor.
All right, well, I did read through the report. I'm familiar with the circumstances here. And I read through the information about your background, your history, and so forth.
I tried to be as candid as I could with them too, but I don't know my family that well, just the main ones, mom, dad, maybe the grandpa. I'm not that connected with the distant family.
So I take all that into account along with what you've had to say here today, and what the attorneys have had to say, and the overall circumstances, the letters that you submitted on your behalf, which I had a chance to read during the break. So I feel like I've got a good overall view of all the facts and circumstances here. I think there are some mitigating factors, or factors that work in your favor. Number one, you don't have any real criminal history at all. You have appeared during the course of the investigation to have been forthright with the police. Always been to court on time. You've always presented yourself as a polite, respectful individual. I think all of those things are factors which work in your favor, and which tend to show the potential for rehabilitation going forward for you. There are, of course, some things that work against you in this case, in the nature of this crime. And I know that what the prosecutor meant by nobody being hurt was your communications with this individual posing as an underage girl. But I think the bigger picture is there are people that are hurt by this type of crime because of what the prosecutor indicated, which is when you have consumers of this type of material, there's going to be creators of this type of material, and those creators prey on disadvantaged, vulnerable young children, get them to do things that are harmful to them. And so the idea with the creation of these laws and through the legislature imposing harsh penalties is if you can stop the consumers, then the creators have no motivation to make this material and harm children. So there certainly are victims of this crime, whether you ever know them or see them, or whether they're ever brought to light. there are children out there right now who are being victimized by this because there are people who want to look at it and will look at it. And that's your real crime here, is you have allowed for the victimization of unknown children. And that's the punishment that the court's looking at here for that activity. And whether you meant to do it or not, that's exactly what you did, is victimize young children. And I don't, I always hear the argument from folks who are charged with this, that they didn't mean to look at it and just popped up on their screen. I don't accept that at all. I think you were out looking for this, and I think your communications with this individual who's posing as a young girl show that this isn't something that was accidental, that you were looking for this material. And so when I talk about the things that lead the court to think there's potential for rehabilitation, those are the types of things that lead me to the conclusion that some punishment is also appropriate here. And I think the sentence that I had in my mind is exactly what the prosecutor suggested. It's a sentence within the middle of the guidelines. I think it appropriately accounts for your wrongful conduct in this case. It's not at the top of the end of the guidelines, which I think accounts for the mitigating factors that I mentioned. So the court is going to sentence you to the Michigan Department of Corrections for a period of 20 months to 10 years. You do have credit for 1 day served. The court is going to order that you register.
I already have. I need to do it.
I've got to state this as part of the sentence.
Sorry.
So the court is going to order that you register with the Michigan Sex Offender Registry Act as indicated in paragraph 1 of the recommendation. Court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. You do have the ability to seek an appeal of the sentence. Mr. Travis, you can have Mr. Way acknowledge receipt.
I don't know what the day is. 25.
Waiver and attorney custody of the state at this time. Also concludes the court's morning docket. Court will be in recess until 1:30.
All rise.
You got it? I can't, Dad. I love you.
A little bit.
I don't even know if you knew what we were doing.
I What's his name?
He was listening to it before and you couldn't hear anything and he was like yelling.
I remember that, yeah, but I don't know who he is. I mean, he's somewhat familiar to me, but I see something.
You get back to your office, can you shoot me that PAT code for Williams?
Yes.
Jail is gonna be wanting.
Yes.
They'll be after me. Great, thank you very much. Sometimes it's super hot. Sometimes
I thought I was
it's
gonna get sick for a second. Alright. 1:30, huh?
Yes.
Quick lunch. If I get one.
Same here. Same here.
are just bombarding. I mean, it's crazy. Yeah, I got that over, yeah, and I think I've got one more thing in there to get in there, which I'm supposed to be doing. But right, a second. Oh, shoot.
See that first one that's up there this afternoon.
Oh, is that a Mertz? Yeah. Sorry, feel free to rummage around.
Give you a bigger
There we
box.
go. I know, I'm so hesitant to go to 2. And then I did put the Nellist file over on the bench.
What's
The
that?
Nellist file is on the bench,
Oh, okay.
just because it's so huge. I didn't
Yeah.
want it to tip over, but if in case I'm not here, well, I guess I will be here because it's 1:30. Never mind. Never mind. You ruined.
Mr. Haas, are you able to hear me okay?
I can hear you. Yes, I can.
Okay, great. I don't see Mr. Prokop joining in. Have you had a chance, have you been able to speak with him at all?
Oh yeah, we have the case settled. We're just working out the details on, because, you know, there's a minor involved.
Okay, so just for the record, this is Goodale versus Marchak, case number 2314356. We have counsel for the plaintiff, Mr. Haas, present by Zoom video. So this was set for a trial prep conference, but Mr. Haas, you're indicating the parties have reached settlement?
Yeah, it's all settled, Your Honor.
Okay, when do you think so there's a minor involved, do we need to have this set for a hearing to approve the settlement?
That's what we're doing right now. From my
Okay, have you
office
gotten it?
anyway. That's what I'm doing, and I'm keeping in touch with Mr. Prokop. The case settled for 75,000.
Okay, do you know if you have a date for my office yet for that hearing?
No, we don't have one yet.
Okay. When do you think you're gonna get that filed?
Oh, you know, probably by the end of the week. It's Wednesday, it's Tuesday today. I'll get it filed by the end of the week.
Okay. The reason why I'm asking is I typically don't take down trial dates, which we have for mid-July right now, until the motion is filed. So if you can get that set before the court, you know, within the next 7 to 14 days, can you do that?
Yes, Your Honor. Of course.
Okay. All right, and then once the court is in receipt of that and we have that set for hearing, the court will take down the trial dates set for July. Anything else that I can address for you while we're on the record today?
Actually, I don't think there is, Your Honor.
Okay. All right, thank you, and you're free to disconnect.
Okay, thank you so much, Your Honor.
Thank you. All right, ma'am, can you tell me your name, please?
Barbara Hartle.
Okay, we'll go on the record in People versus Barbara Hartle, file number 163917. The record should reflect that Ms. Hartle is present today by Zoom video. And we have Mr. Ziegler here on behalf of the people. Ms. Hartle, this is your motion to set aside a conviction from November of 2016 for the crime of assault with intent to do great bodily harm. Is that correct?
Yes.
Okay. And Mr. Ziegler, the court's in receipt of a letter from the Michigan Attorney General's office indicating that Ms. Hartle, her petition does meet the technical requirements. Would you agree with that?
I would.
Okay. So Ms. Hartle, there are two things that the court has to determine today based on what you tell me. First of all, the court has to find that your behavior and your circumstances since this conviction would warrant having it set aside and that it would be in the public interest to have it set aside. So typically I would have you explain to me why you think your case meets those two requirements. Do you have any questions about that?
No, I think I understand.
Okay, so why don't you tell me about your behavior and your circumstances since this conviction was entered that you think would warrant having it set aside?
It's hard to explain the situation. I was in a really bad time in my life and there was a lot of really bad people around me and I was making a lot of bad choices and I drank a lot. And for 6 months of my life, like I drank and this ended up happening. I have rebuilt my life ever since that with not only just working on myself, but with my children. Like we talk about it all the time. We have open communication. You know, I've been able to get back in their life. My son just turned 18 and he graduated this month. And my youngest is turning 15. My other daughter's turning 17. You know, I have 50-50 custody. I took this wake up call in life, I guess, as I wasn't going anywhere. I'm a disabled person. And as somebody that's diagnosed with a progressive disability, that's basically told you're going to be paralyzed at your first decade, you kind of give up on yourself. And I did. And this kind of made me go back to high school. I got an associate's degree, a bachelor's degree, and I just started a master's degree. I am almost wheelchair bound now. I use an electric wheelchair a lot more, but I actually have dreams and goals and want to use my education. This charge is really getting in the way of that also. Obviously it would, especially in the criminal justice field, but not only that, with no experience and having a major charge like this has affected me. There's also been times in my life where I kind of ended up broken out of a relationship, and whether I built a home with a man or not, the home was always in the man's name, so the woman kind of loses. And finding a shelter or somewhere to stay has been extremely hard because of my charges. And so, you know, that's been kind of where I'm afraid when I get older, and if I do need the dependence and need to go somewhere, that I won't be able to because this holds me back. I don't think it's a mistake because it's something that I'll never be able to take back, but it's also something I'll never be able to forgive myself. As much as I can heal from it, I take it every day and learn from it. So,
okay.
I mean, that's kind of all I got.
Okay, all right, thank you. Based on what Ms. Hartle has had to say, in your review of the file, Mr. Ziegler, do the people take any position?
Your Honor, we're supportive of the petition to set aside the conviction. I think Ms. Hartle has demonstrated that she's changed her outlook on life. She's clearly a different person than she was 8 or 9 years ago when this offense occurred. I think her statements today on the record are sincere and speak to a genuine desire to want to work and to want to put this behind her and to open a new chapter. The only thing I would note on the technical side, Your Honor, is that the application lists the conviction as assault with intent to do great bodily harm less than murder, but the conviction is for a felonious assault. So as long as the record is clear that that's the conviction that's being set aside, I would support the court entering an order to that effect.
Okay. All right, so Ms. Hartle, I did review your file as well as your application. I find that you do meet the technical requirements to have this conviction set aside. There's a few things that I would note that I think address the questions of your behavior and circumstances and why it would be in the public interest. I know based on the information you provided that following this conviction, you did go back and get your high school diploma in 2018. In 2020, you graduated with an associate's degree in criminal justice and then went on to get your bachelor's degree in criminal justice with honors in October of 20.
I dual majored. I got criminal justice and I got computer forensics.
Yeah, so Ms. Hartle, I just need to be able to say what I'm going to say. I'm going to grant your petition, so I don't need you to add any more information. I think I have enough here, okay?
Sorry.
That's okay. So again, I graduated with honors with a bachelor's degree in 2024. And so clearly, in my view, you've done a lot since your conviction to try and improve your life, to advance your education and move on from this. It's also clear that based on the conviction that is impairing your ability to move forward with a career based on your degrees that you've earned. And I also agree that it could be a barrier in the future in terms of your health condition and being able to secure long-term care for yourself if and when you need that. I find that it would be in the public interest for you to, number one, be able to use your degrees to pursue a better career, as well as obtain proper care for yourself given your health conditions. So court finds that all the conditions have been met. The court will grant the petition to have the conviction set aside, and the court will issue an order setting aside that conviction. And I probably won't get that done today, but it'll be ready probably tomorrow or the next day if you want to contact the clerk's office here in Kalkaska to get a copy of that for your records, okay?
Okay, thank you very much.
Yep, do you have any questions at all?
No,
Okay, thank you and good luck to you going forward.
thank you.
Smith's file. And I just got this one more and then we can bring in a hearing.
The echoes. Okay. I don't remember the names of the unlawful use of an automobile case, 750-414. And then the resisting and obstructing, I think that was.
Yes, there was.
750.
All right, Ms. Smith, can you unmute yourself, please?
He is a dog.
There we go. Hello?
Hi, is your name Renetta Smith?
Yes.
Okay. Okay, we'll go on the record in Renetta Smith versus Randy Miller, file number 2514723. The record should reflect that Ms. Smith is present today by Zoom video. Ms. Smith, I have this set for entry of a default judgment of divorce today. Is that how you wanted to proceed?
Yes, please.
Okay. So the court notes for the record that Mr. Miller was properly served with the summons and complaint in this matter. He failed to file any kind of answer to that complaint. Default was entered against him back on April 10th. He was provided notice of that default, as well as notice of the date and time of today's hearing, which was 2:30. It's now past 2:30. Mr. Miller has not appeared here either by Zoom or in person. So we can proceed with the judgment of divorce today. Ms. Smith, I'm going to have you raise your right hand so I can swear you in, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hand. Ms. Smith, I'm going to ask you some questions. The questions I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. My first question is you filed the complaint for divorce in this matter and you signed that complaint. Is that true?
Yes, sir.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes, sir.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, sir.
Does that remain true today?
Yes, sir.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir. Our youngest is 21.
All right. Are you currently pregnant?
No, sir.
Are you asking to have your last name changed? Oh, no, you don't have the same last name. Okay, forget that. Strike that question. Under the judgment of divorce, you would not be receiving any alimony or spousal support. Is that correct?
That is correct.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes, sir.
All right. And under this judgment, you're asking the court to order that Mr. Miller has 30 days to retrieve any property that belongs to him. Is that correct?
Yes, sir.
Other than that, have you already, both of you are just going to keep whatever other property you each have in your possession? Is that correct?
Yes, sir.
And you don't own any real estate or real property together?
We do not.
Okay. And so with regard to the cell phone, is that a joint cell phone account or something?
Yes.
All right, so you're asking the court to order that he put that into his name and that he
Yes.
be responsible, Bill?
Yes.
Is that something that you need to sign off on, or I don't understand why he wouldn't already have that just in his own name?
He's under my plan.
Okay. Does he have to do that, or can't you just remove him from your plan if it's your plan?
I probably could.
Okay. All right. And are you both on that plan? Do you get like one bill and you split it, or how does that work?
Yeah, I get one bill. Myself, Randy, and my son, Caleb Smith. Well, our son, Caleb Smith, and my daughter, Erica Smith. So I have 4 phone plans on that.
Okay. So are you saying that he owes you money on that bill now?
No, that's fine.
Okay. So, I mean, I guess, I don't know that, my problem is I can only order what the court has the authority to order.
Yeah.
I think it would be up to you to remove him from your plan. and then you wouldn't be responsible, and then he would have to go get his own cell phone, so
Okay,
I'm gonna just cross that part off.
okay, that's fine.
And I'm gonna indicate in here that that you're gonna remove him and that he needs to get his own cell phone. How does that sound?
Okay, that's fine, thank you.
Okay. And I'm gonna put in here that the defendant, Mr. Miller, has to cooperate with that process. So in other words, if he has to turn in that phone to your provider or whatever and get his own phone, that he has to cooperate with that, okay?
Yes, thank you.
Okay, and then you also have in here about something about the truck insurance.
Okay, so I did, a couple weeks ago, I took my own policy out and he is the only one left on that policy, so.
Okay, so we don't need anything that's taken care of?
Yes, sir, it is.
Okay. Okay, aside from that, are there any issues regarding the division of any assets or debts of the marriage that the court needs to decide?
No, sir.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. Smith. The court will grant the divorce. I've signed that judgment that you provided. If you'd like to get a copy of that for your records, you can contact the clerk's office here in Kalkaska, okay?
Okay, thank you.
Yep, do you have any questions at all?
I do not.
Okay, that's all for today. Your divorce is final.
Thank you so very much.
Yep, you're free to disconnect. Okay, you want to bring in the Harringtons? Mr. Harrington, you get a seat at that table right over there.
I was just gonna ask.
Yeah. Harrington, hi, you can have a seat right there. We're on the record in Harrington versus Harrington. This is file number 2514733. The record should reflect both parties are present here in the courtroom today. I have this set today to enter a consent judgment of divorce. Ms. Harrington, is that how you wanted to proceed?
Yes.
And Mr. Harrington? Yes. Okay. You both raise your right hands, please. You both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hands. So I'm going to ask each of you a series of questions. The questions I'm going to be asking both are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Harrington, as the party filing for divorce, my questions will start with you. You filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
You and Mr. Harrington agreed on how to divide up all the assets and debts of the marriage. Is that true?
Yes.
As part of that agreement, neither of you is going to receive any spousal support or alimony. Is that correct?
Yes.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
Okay. And then in terms of dividing up the assets and debts, I've been provided with a proposed judgment that looks like you signed back on May 29th. Did you go through that judgment before you signed it?
Yes.
And do you agree that dividing things up as provided in that judgment is a fair division of your assets and debts?
Yes.
And by signing that judgment, do you agree to abide by all those conditions?
Yes.
Mr. Harrington, have you heard all the questions that I asked Ms. Harrington?
Yes.
Did you hear all of her answers?
Yes.
Do you have any reason to believe that any of the answers that she gave were untrue?
No.
Again, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever and would not be able to come back later and ask the court for that.
Yes.
And the proposed judgment is also signed by you on May 29th. Prior to signing that, did you review all the provisions in that judgment?
Yes.
Do you agree that the division of the assets and debts as provided in that judgment is fair division?
Yes.
And by signing that, does that mean that you agree to abide by it?
Yes.
The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court has reviewed the judgment, finds that it contains all the provisions required by law. The court is signing that judgment with today's date. So your divorce is final as of today. Ms. Harrington, are you asking to have your last name changed?
Yes, please.
Okay. So from today forward, because the divorce is final, your name will be legally changed. So you'll need to get copies of this judgment, so change your identification documents.
Thank you.
Mr. Harrington, did you have any questions?
No.
Ms. Harrington, did you?
No.
Okay, thank you. That's all for today.
Thank you. How soon will that be ready to be copied and taken care of tomorrow? Okay, great.
Thank you. Thanks for letting those guys in.
Oh, no problem. Anytime, Your Honor.
Is the next one bank versus solid waste?
Yeah,
I don't have that file. Let me go.
I got it.
Oh, okay. Thanks.
Sorry, you weren't here when I.
Okay, good.
I got it. Okay, 1 second here. All right, Mr. Soloway, if you can unmute, please. Thank you. Okay, we're on the record now in Bank of America versus Soloway, file number 2514734. Mr. Zarhan, you're appearing on behalf of plaintiff, is that correct?
Yes, Your Honor.
Okay, and Mr. Soloway, you're appearing on your own behalf, is that correct?
I am.
Okay, so this is set for hearing today on plaintiff's motion for summary disposition. I think we do have a threshold issue, though. I want to hear from both sides on this. I reviewed the file prior to the hearing today, and it appears that this is a file that was transferred by order of Judge Elsenheimer in the 13th Circuit, transferred jurisdiction to this case. But in reviewing the file, it's my understanding, Mr. Soloway, that you're challenging personal jurisdiction, or you did, of the 13th Circuit Court, and that are you challenging the jurisdiction of this court as well, even though the file's been transferred here?
Absolutely. The 13th did not have jurisdiction. Just because they referred a case over doesn't mean that they gave it jurisdiction or that they had jurisdiction. Doesn't mean that at all.
I understand. I'm just trying to understand and get clear for the record what your position is. So you argued that in the 13th Circuit, but that continues to be your position even in here in the 46th Circuit. Is that correct?
That's correct.
Okay, so Mr. Zarhan, in my view, that's a threshold issue that the court would have to determine before passing on your motion for summary disposition. But what's your view on that?
Well, yes, Your Honor, and the defendant was personally served at that Fife Lake, or the Lund Road address in Fife Lake, by personal service, which was determined to be, I believe, in the 46th Circuit Court. So we then, after determining that, the venue was transferred and the defendant was personally served in October of last year at that Fife Lake address, and the jurisdiction was then transferred over to the proper venue. So personal service was effectuated and transferred over to the proper court, which we learned was the 46th Circuit. Personal service remains intact.
Okay, so Mr. Holloway, what's your response to that argument?
Just because I happen to be somewhere doesn't make me a resident. Doesn't give Kalkaska County any jurisdiction. He hasn't shown anything that says that I am a resident of Kalkaska County. In fact, I have a Mississippi driver's license and I vote in Mississippi.
Okay, do you dispute that you were served with the summons and complaint on July 7th, 2024 at 2:59 p.m. at Lund Road in Fife Lake, Michigan?
No, I don't.
Okay. All right, Mr. Zarhan, what's your response to Mr. Soloway's argument?
Well, and Your Honor, by Mr. Soloway not, or I should say by acknowledging the fact that he was personally served at that time, delivering a summons and complaint to the defendant personally, to mean that personal service is effectuated when the defendant is left with documents in their physical control after being offered and then being informed about their contents. That's Barclay versus Crown Building and Dev 241 Mich. App 639. The defendant was served. That was his residence that we had
that the documents were given to him. At the time, it was in the 13th Circuit Court. The defendant's argument was it is not the 13th Circuit Court because this is where I was personally served with these documents. At that last, there was no change of address nor any other address or domicile given after that address. So with that being the last address that was on record, the last confirmed address where the defendant lived, the last confirmed address that the defendant was where he was given physical possession of those documents, which he signed for, that is the jurisdiction, that is the proper jurisdiction until as of now. As of then and as of now. And Mr. Soloway has confirmed as such that he, in fact, was served with those documents.
Okay. All right. I'm going to take a short break. I need to look at some case law. I'm going to ask both of you to just remain on the line for just a couple minutes, and I'll be right back. Okay?
Well, he's making an assumption, and the 13th district made an assumption that it was all about the 13th district. It never was about the 13th district. It was all about me being someone from Mississippi and not from Grand Traverse County, and them being a mix-up regarding what county was being, served and all that crap. So it was never about that, and they never clarified that, and it wasn't my job to clarify that. We are clarifying it today.
Okay. All right. Thank you. I'll be right back on the record in just a couple minutes. I'm going to ask both of you to remain on the line, and I'm just going to put you both in the waiting room, and I'll bring you right back in 5 to 10 minutes. Okay.
Your Honor, just to confirm, did you receive the response to defendant's motion to dismiss?
No. All I got was your motion for summary, so no.
Oh, you don't. Okay, you don't have the motion or the response.
I have Mr. Soloway's motion to dismiss. I have your motion for summary disposition, but I don't have any other filings from either side.
Okay, thank you.
All right. I'll be back on the record in 5 to 10 minutes, as I indicated. Okay, we're back on the record. So as to the question of whether or not this court has jurisdiction over Mr. Soloway, the court points to MCL 600.701, which provides that the existence of any of the following relationships between an individual and the state shall constitute a sufficient basis of jurisdiction to enable the courts of record of this state to exercise personal jurisdiction over the individual and to enable such courts to render personal judgments against that individual. Subsection 1, presence in the state at the time when process is served. So as the file indicates, Mr. Soloway was served with process personally in Fife Lake, Michigan, within Kalkaska County on July 7th of 2024 at 2:59 p.m. So therefore, jurisdiction under 600.701 is satisfied as he was present in the state when he was served with process in this case. So the court denies Mr. Soloway's motion to dismiss for lack of jurisdiction and finds that it does have personal jurisdiction over Mr. Soloway. So with that being determined, Mr. Sarhan, we can proceed with your motion for summary disposition. I did have a chance to review your motion and the brief. Is there anything that you wanted to state in support of that?
No, Your Honor. I apologize to the court. I was operating under the presumption that a response was received, so forgive me for that. Regarding our motion for summary disposition, Your Honor, we'll just rely upon our pleadings as you had a chance to review them and we'll gladly answer any questions the court may still have. Thank you.
All right, Mr. Soloway, do you have any argument regarding Mr. Sarhan's motion for summary disposition?
Well, Your Honor, I would like to adjourn this and take the time to answer his motion for summary disposition, because today I was prepared to deal with jurisdiction, so I did not take the time to deal with all of the other issues that came up, because just jurisdiction is the first item that we had to get through.
All right, Mr. Soloway, I'm not going to grant you any kind of extension. The motion for summary disposition was filed in a timely manner. You were provided notice with the hearing of today. Today's the date for the hearing on that. So if you have any arguments to make, now is the time to make them.
I'm not prepared to make any arguments at this time.
Okay, all right, then the court finds that with any lack of argument to the contrary, and the court having reviewed the motion for summary disposition, it's pretty clear to me, based on the documents submitted in support of that motion, that there was a valid contract that was entered into between Mr. Soloway and the Bank of America, that he did fail to make payments as required under that contract, and that he failed to do so. And so the court finds Bank of America is entitled to a judgment against Mr. Soloway for the outstanding amounts, and the court will grant the motion for summary disposition. Mr. Sarhan, I would just ask that you submit an order reflecting the ruling of the court today and submit that under the 7-day rule.
Yes, Your Honor, we will submit the proposed order and proposed judgment, yes.
All right, that's all I have for today, and both sides are free to disconnect at this time.
Thank you, Judge.
All right, got both counsel connected, so we'll go on the record in IAT versus IAT, file number 2414662. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good morning, or good afternoon, Your Honor. Vivian Atisha Howell on behalf of Joe Ayat.
Coordination Broad on behalf of Lindsay Ayat.
All right, thank you. We're on the record here today for defendant's motion for imposition of a mutual temporary restraining order regarding assets. Counsel, are you ready to proceed on that?
Your Honor, I want to start by apologizing and wasting the court's time and also Ms. Howell's time. We do have a stipulated order. I was under the impression my staff had called when we had signatures late yesterday and was told we could not email the stip, and therefore I thought it most expeditious to just appear and let you know that we had an agreement. I am now being told by Ms. Howell that the staff would have accepted it via email. So we have a stipulated order that has been signed by all parties. I see Vivian wants to correct me as to what her office found out. Regardless, we have a stipulated order that is being submitted to the court.
We reached an agreement, Your Honor, and I concur with what you stated. It's just that the court would have accepted an email indicating that the hearing can be canceled and that we'll mail the stip order over to the court for entry. But that's fine. We do have a stipulated order, and I think Ms. Ascioni's office is going to be sending that over to you. So it's fine.
All right. Okay, yeah, just so counsel's aware, typically my staff, I don't know how other courts handle it, but we need to have a signed stipulation and order before we take things off the docket, because otherwise it gets messy. We get people calling left and right. No, we don't need this. Then the next thing you know, it wasn't what everybody thought it was. So that's probably the reason. But be that as it may, regardless, if we've got a resolution, I'm perfectly happy to accept that and let both of you go on about your day. So
thank you,
counsel. Yep, both counsel are free to disconnect. Thank you.
Thank you so much.
right, whoever's joining us on the phone with the last four digits, 1361, can you tell me your name, please?
Yes, Jim Elliott, plaintiff's attorney.
Okay. All right, so we'll go on the record now.
May I indicate, John Elliott can't get on yet, and he's the one handling the motion. He keeps getting kicked out.
Okay, I'll wait a couple minutes then and see if he's able to join.
It looks like it's coming through. If not, he may just have to do a phone. That's what you might just have to do your phone. Click on it with a phone, John, Nick, with his phone. He needs to give you his phone, and you need to do it now. Is it going through? Nick, is it going through? We're logging on with his phone. What's the status? Forget the camera, just.
All right, Mr. Elliott, are you able to hear me okay?
Yes, I am. I'm sorry about that, Your Honor.
Oh, that's okay. As good as Zoom works, sometimes it doesn't work perfectly. So we're connected now, so that's a good thing. So, all right, we'll go on the record now. This is Nellist versus Kalkaska County Hospital Authority and other parties. This is file number 21-13787. We have Mr. John Elliott connected on behalf of the plaintiffs. We have Mr. Arteav on behalf of Kalkaska defendants, and we have Ms. Beach here on behalf of defendant Munson. So we've got a number of different motions up for hearing today, and along with a status conference too, I believe. And so the way that I would like to deal with these motions is kind of to bifurcate the arguments on these a little bit. What I'd like to do today is go forward with the hearing on plaintiff's motion to reinstate the count for gross negligence and plaintiff's motion to strike the defendant's expert, and in the alternative ask for a Daubert hearing. I'm going to ask Mr. Arteav, for you to renotice for next month the motions for summary disposition under C7 and C10, and the motion for partial summary disposition regarding the the stroke claims. And the reason for that is twofold. Number one, the motion regarding the stroke claims, several of the reply and response briefs I did not see until this morning. They were filed late last week. I had a full docket yesterday in Otsego County, so I did not see those till today. And so I haven't had a chance to fully review those, and I'd like to be able to rule on these motions, in a timely manner without doing a written opinion and waiting for that process. So that's one reason. The other reason is the plaintiffs have objected to Munson's joinder, at least as it relates to the motion for partial summary disposition on the stroke claim, based on the arguments that Munson didn't properly notice that motion out as a separate motion, and it's not merely a joinder with Kalkaska's motion, but actually raises separate and distinct arguments. And so to me, that renoticing those motions out till next month then solves that problem and resolves that objection. And that way plaintiffs will have plenty of time to respond to any new or different arguments that Munson's raising in addition to Kalkaska's. So the two motions for summary disposition, the partial motion for summary and the motion for summary under C7 and C10, for those reasons, I'm going to adjourn the oral argument on those for today. And again, Mr. Arteyev asked that you notice those for hearing in July on the court's regular motion day on Tuesday. Does any counsel have any question about that?
Just quickly, Your Honor, would that be July 1st then? Is it the first week that you have your hearings, or is it? I guess, yeah.
Oh, no, it's like the 8th.
It would be July 8th.
8th, okay. All right, that should be doable. I was a little concerned about my ability to attend the July 1st hearing, but July 8th should be doable then.
Okay.
July 8th.
All right, so, oh, I'm sorry, go ahead, Ms. P.
Sorry, I was just gonna say July 8th works for me, and then if we are treating Munson's joinder and concurrence as its own MSD, does that mean that I will be able to file a reply brief if plaintiff files a response?
Yes, as long as it gets, a judge's copy gets to me before the morning of the hearing.
Okay. Great, thank you.
And I think council's aware of this, but, and I know you guys do a good job of trying to do this, and there's just, this case has had voluminous filings from all sides. But my office is in Otsego County, so it helps if the judge's copies are sent directly to Otsego County as opposed to Kalkaska, because then they have to forward it on to me in Otsego. That's the quickest way for me to get that stuff so I can read it and be ready to give you guys rulings. So that being said, Mr. Elliott, if you would please, I did have a chance to review all the briefs regarding your motion to reinstate the claim for gross negligence. I had a chance to review the depositions of Mr. Miller, Mr. Barronzone, and Mr. Bryan, and the response and reply briefs. So Mr. Elliott, if you would please, any oral argument on that motion.
Yes, thank you, Your Honor, and I will keep it brief. Again, early on, as stated in the motion, we had a hearing on a motion for some disposition due to government immunity arguments. And at that time, Your Honor did dismiss the gross negligent count. We had not had any depositions at that point. As Your Honor is aware, gross negligence means conduct so reckless as to demonstrate a substantial lack of concern for whether an injury results. The discovery has revealed that these individuals knew, they 100% knew that death or serious injury could result. They completely disregarded that. While the defense points out that, well, afterwards they cared for him, supposedly while he was on the ground, even though it was not visible in the video, they supposedly cared for him. That doesn't mean that they didn't disregard a known risk at the time that death or substantial injury could result. and it did result when he was crashed to the ground violently, breaking 7 ribs, suffering a flail chest, and almost passing away. They knew this risk. The testimony revealed that they knew this risk. They disregarded it. Again, defendant Miller can be seen in the video throwing up his hands in frustration before he rips plaintiff out of the ambulance alone. I don't know why he did it. I don't know why he was throwing his hands up. He was clearly perturbed, and he clearly lacked concern for our client suffering this catastrophic injury. The only case the defense relied upon in their response, or the main one that I saw, was a case, the Tarlia case. The case of Tarlia 1 has already been distinguished as being limited to its facts, but it was very, very different in this case. In Tarlia, the plaintiffs were the high school football students' family. This young man had passed away. Unfortunately, one of the causes was heat stroke. In distinguishing this case, the state of Green by Green versus Chardoba in 2021 unpublished opinion, pointing out that in Tarlia, this young man, these were optional drills he was running. He could have taken water breaks at any time. There was absolutely no threat or reason to believe that he was in any harm, or that these people thought that he would have been in harm. He was running around playing games as he wanted to do. He could have taken a break at any time. In Chardoba, that case found that it was a question of fact for gross negligence, where a police 911 operator failed to check that the volume when he took over his shift was high enough up that he could hear the calls. It's not that he had some absolute knowledge that something was very likely to happen, as did in this case, in these defendants. It was that he failed to check whether or not the volume was up on his calls, and as a result, he failed to respond to a call that came in. I'd ask you to look at the facts of that case compared to this one, given that we now have the unique knowledge to know, as has been admitted by these defendants, that they were aware of this severe risk and they engage in the conduct anyways. I think that's at the very least a question of fact for the jury to determine if there was gross negligence in this matter.
All right, thank you. Mr. Arteav?
Thank you, Your Honor. First off, I think this court can understand we certainly object to plaintiff's reading of our defendant's deposition testimony. I don't think there was anything that indicated they knowingly violated any sort of policy and procedure specifically to harm Mr. Nellis, which seems like what they're implying. But regardless of that, Your Honor, the fact of the matter is there's simply no procedural basis to even ask for this type of relief at this point. This is essentially a motion a motion for reconsideration that was filed about 20 months after this court issued its ruling. I don't see any court rule cited by the plaintiff. I don't see a statute cited by the plaintiff that allows them to request this type of relief, and basically saying that, oh, well, after all this time, actually, you should reinstate this gross negligence count. Ultimately, Your Honor, too, I'm not sure why plaintiff's counsel indicates that we only rely on one case. In support of our argument, we actually cite to several, and co-defendants do as well, specifically for the fact that testimony and evidence regarding non-compliance with certain policies or procedures is irrelevant towards establishing a gross negligence claim. That's evidence of an ordinary negligence claim, which is the only remaining claim in this case. So we, for the record, we cite to, 1 second here, several published opinions too, including from the Supreme Court, that indicates that essentially evidence of non-compliance with certain standards or procedures, is an evidence of gross negligence. So any such testimony that they're referring to really doesn't establish or warrant reconsideration of that particular dismissal. But yeah, we cite to Maiden v. Roswood, which is a Supreme Court case, Rakowski v. Sarb, which is a Michigan Court of Appeals case, Zhu v. Gay, which is a Michigan Court of Appeals case, and ultimately, the Tarlia case that the plaintiff referred to in this case, but all of those essentially support our argument that the very evidence that plaintiff's pointing to that should reestablish this gross negligence claim, is really irrelevant to gross negligence in general. Finally, Your Honor, I look back at the hearing from when you dismissed the gross negligence claim, and the decision there was really made based on your own review of the surveillance video itself. And basically, when we point to the standard for gross negligence, and we really point to the Tarlia for the standard that it indicates, and saying that it's as though the objective observer watched the actor and he could conclude reasonably that the actor simply did not care about the safety or welfare of those in charge. The court made a clear decision that, based on its own review of the video as an objective observer of what's going on, that a gross negligence claim, that a jury couldn't find a gross negligence claim in this case. So I think with that, Your Honor, I'd ask for dismissal of this particular motion. Thank you.
Thank you. Ms. Beach, I don't know that Munson has a dog in the fight on this motion. Anything that you wanted to add?
Very briefly, Your Honor. Again, Karen Beach for Munson Hospital. We did a supply in our response brief a couple of cases where the Court of Appeals has looked at what constitutes gross negligence in an emergency medicine medical technician setting. And the bar is very high, even in cases where it seems like there was a failure to perform basic EMT functions like assessing vital signs, assessing the competence to refuse treatment, even failing to transport the patient to the hospital. None of that was considered to rise to the level of gross negligence in the EMT context. And so for the reasons stated by Brother Counsel, and the reason that the bar for gross negligence is still so high, even in an EMT context, we would ask the court to deny the motion.
Great, thank you. Mr. Elliott, anything in response?
Your Honor, though, no, I stand on my motion. The only thing I would point out as far as a procedural argument by Mr. Artev is, Your Honor, we didn't have this discovery at the time. I also don't believe there's any procedural court rule that the defendants relied upon by filing a brief that was over the 20-page limit. They just did it anyways, not getting permission ahead of time like plaintiff did when we filed our original brief in response to 2 motions for summary disposition that had previously totaled 40 pages. So I think there is a reason here, given that there's discovery has been had and that originally it was based upon limited discovery. Other than that, I stand upon the motion.
All right, thank you. So again, I did have a chance to review the motion and the briefs and the accompanying information. I think it's an interesting argument from a procedural standpoint. Certainly, I wasn't able to locate any kind of authority necessarily that would allow the court to re-examine a portion of a claim that it had previously dismissed with prejudice outside of a motion for reconsideration, which I think still arguably would allow the court to re-examine it for good cause, even as late as it's been. As Mr. O'Neill pointed out, newly discovered evidence, newly developed evidence through the course of discovery could certainly, I think, provide good cause. But ultimately, I don't think the court's consideration turns on the procedural aspect of this, but really on the substantive aspect of it. Both parties acknowledge that this proper standard for finding of gross negligence is conduct so reckless as to demonstrate substantial lack of concern for whether an injury would result. And again, I think for the court to reinstate this claim, given its prior ruling, the court would have to find that this additional discovery now creates a question of fact on that issue where previously there was not one. And in my view, plaintiff's argument is essentially that defendants Miller and Bryan knew that improper operation of the stretcher and the cot, that they knew failure to follow the manuals associated with that and the proper operation of it. Failure to transport a person, particularly of Mr. Nella's size and his condition, with his deficits to the one side as a result of the stroke. That they knew that improperly transporting him and tipping over that stretcher could result in serious injury or death, and that therefore that failure to do so equates to at least a question of fact as to whether or not they acted with gross negligence. And in my view, the testimony of Berenzone, Miller, and Bryan, while certainly fleshes out what they were thinking and observing, and with regard to Mr. Berenzone, the training under the circumstances, fleshes out all of those things. It doesn't add a lot to the court's view of whether or not there's a question of fact on gross negligence. I think the cases cited by the defendants support that. I think certainly, again, viewing this in the context of what is the duty of Miller and Bryan as it relates to Mr. Nellis and the transportation and getting him out of that ambulance and into the Eden Center. They obviously have a duty to comply with the manual involving the stretcher, a proper operation of the stretcher and proper transport of them. And to the extent that they breach that duty, and there's certainly more than enough evidence to show that they did breach that duty to survive a motion for summary disposition. But is that something beyond just their ordinary duty of care? And the court finds that it is not. That in order to find gross negligence, there would have had to been conduct over and above just a breach of what I view as their ordinary duty of care, which is to follow the regulations, follow the manual, follow proper operation and transport. And, I equated the example that I thought of as I was considering this is, everybody has a duty to adhere to traffic laws when you're operating a vehicle. Everybody knows if you run a red light, that could result in serious injury or death. But simply failing to stop at a red light, driving distracted and failing to stop, adjusting your radio and failing to see a red light and going through it and causing an accident that results in serious injury doesn't necessarily equate to gross negligence. And I view this case as analogous to that. There would have to be something more, I think, that Miller and Bryan did that demonstrated recklessness and a substantial lack of concern outside of just a failure to adhere to what I would consider their ordinary duty in this case. And I would equate that to somebody, tying a blindfold around their eyes and then getting in a car and driving. That's clearly reckless. That's clearly a lack of substantial concern for whether an injury could result to someone else. And I just don't see conduct here that rises to that level. And I think in reading the transcripts of their depositions, and counsel was there, I'm just reading it on paper, but in my view, I did not get the sense through the testimony of Miller and Bryan that they didn't care about Mr. Nellis as they were engaging in this transport, that they were somehow, so distracted or so bothered by something else that was going on, that they, weren't trying to take what they viewed, at least at the time, as proper precautions. And again, that certainly results in a breach of a duty of care, potentially, if a jury finds that, and there's sufficient evidence to support surviving a motion for summary disposition, but I just don't think it rises to the level of gross negligence. I don't think a finding of gross negligence is dictated by the results, the amount of harm that results from a breach of a duty. I don't think it flows from the degree of risk or even a knowledge of that risk. I think it has to flow from the actual conduct of the actors. And is there sufficient evidence that it was so reckless that it demonstrated a substantial lack of concern? And again, the court finds that it does not in this case as a matter of law. So the court denies the motion to reinstate that count. And moving on to the next motion, which is the motion to exclude Dr. Gable and his testimony as an expert. I did have a chance to review in detail his deposition. I also had a chance to review the written briefs of the parties. I had a chance to review Dr. Raja's deposition testimony as well in detail, as well as MCL 600.2955 and the corresponding rules of evidence. Mr. O'Neill, your oral argument with regard to that motion, please.
Thank you, Your Honor. It's Mr. Elliott.
I'm sorry, Mr. Elliott. Sorry.
Oh, no problem. You said Elliott before. It took me a second to realize you were talking to me.
No, it's been a long day. Go ahead.
Got it. Your Honor, again, I'll be brief. I think it was thoroughly brief, this motion. In the defense doesn't dispute, Edry versus Edelman points out the seriousness of unsupported opinion and why literature is such a high prong on this list. But I would want to point out it is not simply the lack of literature on this. Dr. Gebel has testified, one, that he's never testified about this issue. Two, he's testified he's never published about this issue. Significantly, he has testified that to even conduct a study to prove what he claims to offer an opinion on would be unethical, in part because you would have to voluntarily ask someone to avoid this therapy that he is claiming is not necessary. He also acknowledges that there is literature that contradicts what he says. However, that must, even though he didn't cite anything or reference it, he says, well, that may be applicable to minor strokes. He doesn't say how, but he acknowledges that it's out there. The case that is pointed to by the defense that's asking this court to disregard the fact that there is no authority that supports Dr. Gebel's claim is Danoff versus Fahim, 513 Mish 4.7. This case is very distinguishable in the fact that, and I'm looking right at page 451 of that case, the Supreme Court points out that the reason that there was no literature to support this doctor's opinion is that the condition or the occurrence was so rare that there would likely be no literature on it. They go on multiple times, and then they point at the very end where they're saying why they allowed his testimony to go forward was that this rarity is the key fact that makes the difference. And that's on page 451. This is not a rare occurrence. Dr. Gebel testified that he's seen, I think, hundreds of patients that have had delays in stroke therapy. He didn't go on to testify that they've not made more significant recoveries. In fact, Dr. Raja also has said he's seen hundreds of these individuals testify and that they have all made significant, or not all of them, but several of them have made significant recovery when they have, even with the same types of stroke, when they have had that important therapy. Your Honor, we also have Miss Dawson, Rachel Dawson. And that I know is addressed in defendants partially in their partial summary disposition motion, why they think Your Honor should not consider her. And they rely upon a case that was, again, very distinguishable from the incident one, in which a physical therapist was trying to offer testimony on a underlying medical diagnosis. That's not the case here. Dr. Raja testified that my client was ready for and discharged for therapy, that he needed that therapy, and that they want to get it in as soon as possible, as soon as medically able, and that he was medically able when he was discharged to go to KCHA subacute rehab to begin it. He was delayed. Dr. Raja testified when reviewing the medical records that even a 1-month delay would be significant for Mr. Nellis. There is absolutely zero support for Dr. Gebel's opinion here. There's no authority. There's no He says there's no authority, he admits it. There's no literature, there's not even a study, because to even conduct one would be unethical, showing there clearly is some detriment to not having this stroke therapy at the time. I believe our motion states clearly why he should not be allowed, and I'd ask you to strike him as an expert witness.
Thank you, Mr. Arteaga.
Thank you, Your Honor. I think just kind of off the top and piggybacking off of plaintiff's argument there, really their motion is basically relying on the only factor that's actually relevant under MRA 702 or MCL 600-29551. Basically, their argument is out of those factors, the only reason he should be stricken is because he couldn't point to specific medical literature or didn't point to specific medical literature in support of his opinion. Those other factors that plaintiff's counsel pointed out to, like never previously testifying on this issue or never publishing on this particular topic, those are not factors that are considered under that particular statute. And kind of going back to the top of this argument, Your Honor, that's really the whole point of the Danoff case, is saying that medical literature on its own, or lack of medical literature in support of a specific opinion on its own, is not enough to strike an expert or deem that expert unqualified. Really the gist of the case is that there are a multitude of factors that should be considered. And when we consider all the factors in this case, or with Dr. Gebel specifically, he certainly passes the MRE 702 test and under the factors of MCL 600-29551. First off, Your Honor, Dr. Gebel is clearly qualified to testify on issues related to strokes, diagnosing strokes, the effect of strokes on patients, and ultimately, relevant to this case, whether therapy would have made any difference in Mr. Nellis' outcome in this case. Specifically, as we point out in our brief, Dr. Gebel is triple board certified. He's a neurologist, he's a vascular neurologist, and is board certified in neurocritical care. He regularly, that's pretty much all he does, is deal with stroke patients on a daily basis. He previously followed up with these stroke patients after they had received their thrombectomies and were discharged from these emergency room settings. So he knows how to read CT scans. He knows how to interpret medical records. He knows how to read operative notes for thrombectomies like that of Dr. Raja's. And with that knowledge, he applies, he reviewed and analyzed Mr. Nellis' particular medical records and his imaging, and came to the conclusion that I think we've pointed out in our brief is a little different than how plaintiff's counsel is characterizing his testimony. His ultimate testimony, and the reason why his and not to bleed into our summary disposition motion, but ultimately his testimony is relevant in this case because he says that therapy, regardless of timing or intensity, is irrelevant to this case because Mr. Nellis experienced 54 cc's of dead brain tissue from a severe stroke that ultimately, where he suffered a core infarct that caused dead brain tissue in a key part of his brain that dictates speech and right-sided extremity function. No amount of therapy, no matter when or when, would change that. So ultimately, that's why he doesn't think the fall at issue really made any difference in Mr. Nellis' ultimate outcome. It's not that he doesn't think that in general, there's a delay in therapy and for any and all patients, but when looking at Mr. Nellis' specific case in here, under these circumstances, applying his knowledge, experience, and his qualifications, he can certainly say that. Top of that, Your Honor, when we're considering additional factors under MCL 600-2955, essentially the crux of it is making sure that experts aren't just testifying based on speculation or guesses or assumptions. Again, he's reviewing medical records and specific CT imaging. And more importantly, Your Honor, his opinions are pretty much mirroring that of Dr. Raja, who also indicated that Mr. Nellis experienced a severe core infarct to a specific part of his brain that impacts his right-sided extremity function and his speech ability. And ultimately, Dr. Raja's deposition testimony, as we pointed out in our briefing, matches that. So in essence, Your Honor, there's nothing to suggest that Dr. Gebel's analysis in this case or his opinions were based on some sort of guessing or speculation or essentially kind of him just, making up something for the benefit of our argument. Moreover, Your Honor, I think it's really important to point out that, and I don't know, I haven't been practicing that long, but I've never really seen a Daubert motion be filed when the plaintiff's counsel doesn't have their own expert to essentially set the standard for what Dr. Gebel should be basing his opinions off of. And that's really the key distinction between the Idri case and the Eller case that they rely on in this case. In that situation, the reason why medical literature was actually an important factor and caused dismissal of the plaintiff's expert was because defendants presented direct contradictory medical literature to the plaintiff's own expert's opinion. So in that case, when they couldn't rebut those opinions with their own medical literature, that's when it became appropriate to strike on that basis. That's not what we have here, Your Honor. This is not a situation where plaintiff presented their own expert and said, yeah, this core infarct that, they could recover from that if they had earlier therapy or if they had any therapy. And then, they present us with some sort of literature that says that, and then Dr. Gebel says he disagrees with it but can't come up with his own literature. That's not the situation we have here. And I think also this is ultimately more similar to the Danoff case because Dr. Gebel does explain exactly why plaintiff's own argument is speculative, essentially saying that earlier therapy or delays in therapy would have made a difference in Mr. Nellis' outcome is essentially speculative. There's really no evidence in this case to suggest otherwise, specifically considering Mr. Nellis' unique condition and his specific diagnosis of what type of stroke he had and the nature and severity and where that stroke occurred. So to say that this is not a rare occurrence, unlike Danoff, I don't think that's entirely accurate. I think, Mr. Nellis' situation does kind of warrant that same analysis under the Danoff case. So ultimately, Your Honor, I think because they're really, Dr. Gebel does testify quite closely to what Dr. Raja also testified to. There's really no basis to say that that he, his opinion testimony is unreliable in this case simply because he didn't rely on medical literature to supply that analysis. So with that, Your Honor, I ask this court to deny plaintiff's motion. Thank you.
Thank you. Ms. Beach, anything that you wanted to add to that argument?
Thank you, Your Honor. Just briefly that there's no basis for distinguishing Danhoff based on the reason why literature is not available on an issue. I've certainly argued many Daubert motions on the other side where I've said, well, the plaintiff doesn't have any literature to support this theory. And what the plaintiff says is, well, it would be unethical to conduct medical research on, for example, depriving a baby of oxygen. And that's the reason why no literature exists. And the courts have accepted that as a valid reason for why no literature exists, and then gone on to say, despite the lack of literature, the expert's testimony is still reliable. So I think we have the same situation here. Danhoff is not distinguishable. It's directly on point. And if this court strikes Dr. Gebel for the reason that he has no literature to support his opinion, the court would be committing the exact same error that got reversed in Danhoff. So the motion should be denied.
Thank you. Mr. Elliott, your motion, anything in response?
Very briefly, Your Honor. I don't understand why both defendants, counsel are alleging that our only basis was the lack of literature. 600.29, MCL 600.2955 has several factors. One is whether the opinion and its basis have been subjected to scientific testing and replication. That has not happened. Whether the opinion and its basis have been subjected to peer review publication. That has not happened. Whether there's generally accepted standards governing the application and interpretation of this method. There is not. It's been testified that there's not. Whether this is generally accepted opinion within the relevant expert community, there is no basis, according to what the defense has presented. It's their duty to present this information. They're expert. That has not been presented. And again, in fact, Dr. Raja has testified numerous patients of his own have made much better recoveries than Mr. Nellis that did have the exact same type of stroke as him, that did have a double blockage. And when he was able to open both arteries or both veins, which he did in this case do, and he was able to do. Additionally, all that Dr. Gebel reviewed was whatever defense counsel gave him. He testified he didn't look at everything and say, this is what I need to see to make a decision. Defense counsel gave him whatever records they wanted him to see. They gave him an index to look at with it, and that's what he made this decision on. Again, with absolutely no support, despite the fact that it seems like there is evidence that Dr. Raja himself said that this type of infarct could be overcome, because it was not just a 54 cc's infarct, there was 200 cc's of recoverable brain, savable brain, that Mr. Nellis would have had the chance to go after and fight to regain if he had been given therapy at that time, and he was never given that opportunity. So, Your Honor, I would ask you to strike Dr. Gebel. I do not believe he meets the criteria to present expert testimony on this issue.
Your Honor, can I briefly just address something? I just want to make a point that, you know, the fact that plaintiff's counsel is continuously indicating that Dr. Raja somehow testified that he's had numerous patients who's had the exact same type of stroke as Mr. Nellis and then recovered fully from that because they didn't fall. That's not what Dr. Raja testified to. And I know that Your Honor, you've read the deposition testimony, but Dr. Raja does make a distinction between why Mr. Nellis' specific case and recovery was more difficult than those other patients. So, you know, I just wanted to make a point to that. And additionally, the 200 cc's of recoverable brain, again, Your Honor, that implies that he wasn't able to recover that through therapy that he's done in this case. And there's been absolutely no evidence that the therapy that's been done in this case, you know, wasn't effective in that regard. So I just wanted to point those two things out. Sorry, I know responses to replies aren't great, but just want to make those points.
All right, again, Mr. Elliott, anything that you wanted to say? I'll give you the last word.
Only, Your Honor, that we have never said that Mr. Nellis would have been expected to make a full recovery, just that his recovery, contrary to that, I never said Dr. Raja said that. He said he's had people with very similar strokes. He said the same severe strokes, same double blockages, have very significant, much better recoveries. Our argument has never been that Mr. Nellis was going to make a 100% recovery. The argument was, as has been supported by, in my opinion, by the testimony, he would have made a more significant recovery than he has. The full amount, and this will be addressed in the motion for summary disposition, the partial motion regarding damages, the full amount is unknown, and all the witnesses testify to that. But there was clearly a deficit here, and Dr. Gebel's opinion that there is no deficit has absolutely no support. And that's why we asked for it to be stricken.
Okay, all right, thank you. Again, I had an opportunity to review all the materials relevant to this motion and the law cited by the parties. I always start out rulings on motions to exclude experts for a lack of reliability by reiterating what I view as the court standard, and that is that the court is, or the court's role, I should say, which is as the gatekeeper here to determine a minimum level of reliability. And it's the jury ultimately that decides whether and to what extent that they accept an expert's opinion. And even the jury instructions tell the jury that experts are allowed to give opinions on matters and that they're experts on, but the jury doesn't have to believe or accept that expert's opinion. And so the court's role here really is only to make a determination as to whether or not that expert's opinion, number one, is going to be helpful to the jury in understanding the issues. In other words, to assist the trier of fact, and whether it's reliable enough that the jury should hear it, and that it's reliable enough to be a basis for a jury to make a decision. And in that regard, we have MRE 702 and MCL 600.2955 to guide the court in making that reliability determination. And I adopt the standards as they've been outlined by the parties in making that decision. I think in this case in particular, for the reasons I think fully articulated by Dr. Gebel during his deposition, and even Dr. Raja, is that there isn't a lot of scientific testing or application of scientific methodology in determining the effect of a delay in rehabilitation after a stroke. For the reasons that they both stated, and in particular, Dr. Gebel, and which make complete sense, that you're not going to purposely deny somebody rehabilitation after a stroke to study what that delay, what effect that delay would have in their ultimate recovery, and then give therapy to other people and then compare them. So, I mean, that makes perfect sense to me, and I think to everybody else, frankly. So this isn't a case where there's a lot of scientific studies out there. The other thing that I think came out through the testimony of Dr. Gebel and Dr. Raja is that where there is literature, what it really discusses is when people get the most benefit from therapy following a stroke in terms of timing, but doesn't really talk about how much or how adversely impacted a person is by a delay. And I think that's a distinction there. And again, shows why I think there's a lack of literature, which I understand is not the only basis here for plaintiff's argument, but the fact of any kind of studies and those types of scientific evidence that Dr. Gebel could rely on in giving his opinion, aside from the fact that Dr. Gebel in his testimony pretty clearly says that, I'm relying on my knowledge, education, training, and experience, and not necessarily on any scientific studies. And so that's where I think the Ehler case really comes into play. And in my view, that case discusses expert testimony where the issue isn't one where there's a lot of scientific testing or application of scientific methodology to base the opinion on. And Ehler indicates that in some cases, all those factors under 2955 may not be relevant, such as scientific testing and replication, but that even where those aren't relevant and the expert's opinion comes primarily from education, training, and experience, it still has to be based on scientific methods and procedures of science, rather than just that expert's subjective belief or unsupported speculation. And so that's what really how I'm looking at Dr. Gebel's testimony here is it based on methods and procedures of science, or is it a subjective belief or unsupported speculation? And in looking at his opinions, I agree with Mr. Artea's characterization that Dr. Gebel's testimony is really, he's not really giving an opinion on the general proposition that a delay in rehabilitation does not affect the extent of recovery. That's not what I got from his testimony. And I think he pretty clearly, along with Dr. Raja, both state that this is really an unknown area of science, and nobody really knows why there's that, as they describe, that plasticity, and whether that spontaneously happens or whether it's a result of therapy. Everybody suspects that therapy helps that process, but nobody knows to what degree it really helps that process. And I think both of those experts, or both of those doctors, testified to that. So I don't think the opinion here is really that that a delay in rehabilitation would not affect the extent of recovery. I think Dr. Goebbels' opinion here is really based on plaintiff's stroke, in particular, the type of stroke that he had, what areas it affected, the extent of the stroke, and what Dr. Goebbels would have expected to see regarding his improvement, regardless of whether or when rehab was started. And so, and Dr. Goebbels' opinion is that because of the nature of the plaintiff's stroke, that the delay did not affect the degree to which he ultimately recovered. And Dr. Goebbels' opinion, while it wasn't based on scientific studies or literature and so forth, which again, I don't think it could have been in this particular case, it was based on scientific knowledge. He didn't testify, well, it's just because that's what I think. He testified based on my review of Mr. Nellis' medical records, the type of stroke he had, the lack of additional injury that result to his brain anyway, that resulted from the fall. You know, his opinion wasn't subjective or based on unsupported speculation. He grounded his opinion in the medical evidence and the facts that medical evidence provided as to Mr. Nellis' condition. So I find, again, looking at the Ehler case, that his opinion was based on methods and procedures of science, and not based on a subjective belief or unsupported speculation. And so, again, looking at the court's role as a gatekeeper, I think there's fertile ground here for cross-examination. I think there's plenty of arguments to be made by the plaintiff that the jury should not accept his opinion or should not fully accept it to the extent that he gives it. But again, the question here is it sufficiently reliable such that the jury should hear it, and the court finds that it is. So the court will deny the motion to exclude that testimony. Because defense counsel ultimately prevailed on both these motions, I'm going to ask Mr. Artea or Ms. Beach to prepare an order reflecting the ruling of the court as to these two motions and submit that under the 7-day rule. And then again, to renotice the motions for summary, which, looking at the time, we've been going for an hour. We likely would not have gotten to those motions anyway today. So we'll proceed further once we get another time in July. I will also proceed with the status conference at that time. I'd like to get all the motions ruled on, and then we'll address the status conference at that date in July. Mr. Elliott, anything else that we need to address for the record today?
Not for the record, Your Honor, more just housekeeping with regard to the July status conference and the motions. Is that going to be also at 3:30 or?
I don't know, but Mr. Artea, you'll need to contact my office to get a time from Jennifer. I'm gonna ask her to try and set aside a 2-hour block for us so that we can get through all of it. I don't think an hour is going to be enough, just based on how long it's taken today.
Your Honor, just for your notice, Jennifer did just email the parties and indicated that July 8th was already booked for everyone. So she said it next available date is August 4th at 2 p.m. So I did just get that email while we were in the hearing.
Okay, so that's probably when we'll have to go forward then.
But yeah, we can notice it for that date then.
In your just looking forward then from there, you know, this case has been going on for 4 years. My client's 78 years old now. Assuming that the case is going on to trial, can you give us any idea of when we could potentially get the next trial date? I don't think it would take more than 30 days to get witnesses subpoenaed after the motion. I don't know how your calendar is, but my client again has been waiting for 4 years.
Well, there's been a lot of motion practice in this case. So we've got stacks and stacks of files related, 12 volumes of files related to this case. So I think the court's been timely in getting rulings out to the parties for the most part. So we've been moving it along as fast as we can. I can tell you this, I don't know what my trial calendar is, but based on the age of this case, it will have priority over all civil cases. And the only matters that would have priority over this would be criminal matters where I have a defendant that's lodged and the time limits for criminal matters are would require them to have precedence. But I would certainly get this on for the earliest possible trial dates. But sitting here today, I do not know what the calendar looks like beyond the summer.
I understand. I appreciate it, Your Honor.
Yep. Okay.
Thank you.
All right. Thank you, counsel. That's all for today, and all parties are free to disconnect at this time.
Thank you, Judge.
Karen, I'll prepare the order. So.
Sounds good. Thanks.
Right, thanks.
That also concludes the court's afternoon docket. The court will be in recess until 9 a.m. tomorrow.